if a partition commission is
This
appointed.
is not part of a larger litigation, but
No, what is the area of the flat? Each of the flats you showed me, but 2000 square feet. So it has to be royalty money for one and possession for the other. So that takes care of it all.
so let them agree. Two of us are together, two of them are together. Let them agree to royalty money here and now.
The co-owner who is not the co-owner of the other one cannot agree for anything regarding the other property, 3B. Cannot agree because he does not have locus standi to agree.
To go back to 3A.
You by yourselves have smashed the thing and
no,
created a.
But if I have, then my lord, because law cannot leave me.
In law 2, you have a remedy. That law, as per law, the two flats are two different, entirely different properties for all practical purposes. You have had your mutation, you are paying taxes separately, you have purchased by two deeds.
Yes.
So these are different flats.
Yes.
You may live together, you may have an interaction between yourselves, the family wise.
But now that we have started fighting and we are fighting for 15 years, I've been thrown out. I
follow countries, what the countries do. But your bathroom is in his portion and his living room is in your portion. Yeah. So you can keep a no man's land also.
Yes, but
instead of the boundary wall, there will be a notional boundary.
No, but there has to be one effective decree which I can pray for.
The
law cannot leave me without
two properties cannot be joined together, Mr. Chaudhary.
In a partition suit.
In one suit, they cannot be joined because they are owned by, in a partition suit, obviously, because they are owned by different sets of co-owners.
If I accept that position, then for an effective partition, I will have to implead the owners of flat 3A and B only for the purpose of dividing the property.
3A is a different property altogether. 3B is a different property already.
Correct. That
you can always build a boundary wall in your own property. The joint owners can always build a boundary wall, and if that is allocated to somebody, he can always. The best thing would be to allocate. I mean, if it is at all allocated, to allocate the common portion between the two to the person who is common in both the properties.
Here there cannot be any settlement because the
no. I'm speaking of the partition. If I was the partition commissioner, either one flat to one, royalty money to the other, or B is the common. Say A, B, C, 3 persons are there, or 1, 2, 3, 3 persons are there. 2 is common in both. So this is that entire property. So 2 is given the middle of that property. But that would be a peculiar scenario because 2,100 square feet total is 4,200.
Yes.
One should be given the property and the others
there are two, effectively, my lord, there are two owners. Me, my lord, and the defendant number 3 are together. And defendant numbers 1 and 2 are together.
We can only do this, Mr. Chaudhary. We can say that the conclusion, this observation in the middle, in paragraph number 105, this is a stray observation, this is an incorrect observation. But we give our own reasons. That cannot be effectively dealt with for determining the share of the plaintiffs. It can very well be effectively dealt with separately because these are separate properties by different dates.
Milord, may I do some research and come back?
What research?
Normally, Milord, I...
No. Must have done your research before you came here.
No, Milord.
No, not post-facto research.
No, now that I am faced with this...
Common hodgepodge,
I want to, Milord, really think about it once. Even if I accept, Milord, this, that... I understand what is falling from your lordship. I appreciate it. We can do this.
We can expunge 3B altogether from the... Because plaintiff here is not a co-owner in 3B.
Yes.
Or plaintiff, no.
Yes, your lordship is right.
He is not a co-owner.
Yes, so 3B can be expunged.
He could not include 3B in the first place. He does not have any locus standi.
Very well.
So we'll just expunge 3B from the hodgepodge of this suit and permit the co-owners of that suit to file a fresh partition suit. We can do that and dispose of this.
Just give me one more indulgence. Also, my lord, in fairness of things, since we are all parties here, all owners of 3B are also before your lordship.
One is common. The common one is sitting. The locations of the council is as per the shares.
No, my lord. That is misleading.
He is common. He is common.
That is designed to mislead. They have chosen how to sit in a manner.
He is a co-owner in both the properties.
To keep your lordships guessing. Mr. Mitra is my principal adversary. Mr.
Whatever. That is between yourselves. But regarding the property, we see the law.
Regarding the property,
we can see the sale deeds visually. I mean, this is a projection of the sale deeds.
He is opposing me. He is supporting me.
Between yourselves.
Now, my lord.
We'll just expunge that property.
Yes, but then
Right,
let
the
me-
trial court was right. 3A, plaintiff could not have filed a suit in respect of 3B at
3B.
all.
But let me please also facilitate separation of 3A and 3B by putting up the wall. Otherwise, it's a paper decree.
No, we cannot do it from here.
In the presence of owners of 3B,
You can always put up a wall on your own property. The co-owners of that property can always put up a wall in on their property. And if it is if it is allocated to somebody, the partition commissioner's report will definitely include something like that. But we cannot dictate the partition commissioner's report from in an appeal against the preliminary
so,
decree.
my lord, this observation from your lordship that I'm
Wall.
yes, I'm entitled to approach the partition commissioner for putting up a wall between 3 and 3.
That's the
Very well. If we both
that-
agreed,
that-
no problem.
no, that's the impugned order records. That's the impugned order records that matter. That's the process the partition suit proceeds.
Very well. If that is the stand, please record it and I'll restrict it to 3A. 3B can be expunged.
Lordship will kindly see the last paragraph.
Yeah.
They have given time to that time. Yes, the page 83. Failing which the party has liberty to get a decree executed through the appointment of partition commission. That's what how a partition suit proceeds. A preliminary decree given, if amicable.
No, that is obviously that will happen.
That's what Mr. Chaudhary is saying. They have to apply before the court below any event.
No, partition commission, when a partition commission is appointed, Mr. Chaudhary, you know the procedure. Both of you will be heard by the partition commissioner. In your presence, the commission will be held. And you can always file an exception. You can cross-examine the partition commissioner. You have a full-fledged right. It's a self-contained procedure.
Yes, but please give me this liberty. Otherwise, I will face difficulty. I wanted your lordship
Trying to
is
say that we expunge 3B from the hotspot of this property suit altogether because plaintiff does not have any right, locus standi, to file any suit regarding 3B. That will take care of your, if then it is between you and them.
yes. Then
owner.
the problem will be that partition
We can
commissioner.
record this. We can record subject to hearing. We have not yet heard them. We can record this that you apprehend that the you cannot create a boundary wall between 3 and 3B.
Yes.
We may observe that there is nothing in law to prevent you from doing that. The owners of a property from giving a boundary to their property. We may observe that much, but we cannot go beyond that in an appeal against a preliminary decree. The actual allocation has to be done by the commissioner. And the best way it can be done probably is to give him in the middle or I mean, that will be a peculiar partition, or to give the property to someone, let him enjoy 4,200 and the others will be given royalty money and you should elsewhere.
Not one day for
Jointness of the property is gone the moment the partition suit is filed and you contest it to the nail. So jointness, forget the jointness of that property.
No, I am only wondering, my lord, whether I can.
Rather the jointness of the family.
Yes, jointness is gone last 15 years. They are fighting.
Yes. This is pending for last 15 years.
Yes.
This suit.
May I just take a minute? 15 years. May I just take a minute, my lord?
No.
Yes, let me tell your lordship why, my lord. Sometimes I may not cross the line of being unreasonable in this matter.
Yes.
This matter, despite 3 or 4 orders for expeditious disposal
Suit is of not of 23.
No, this is 2010.
This is a renumbering of the suit.
Yes, 2010 suit. Now, three orders of this court and my lord, the Supreme Court for expeditious disposal were ignored. Some 100 adjournments were taken. Ultimately, we filed an application for criminal contempt, saying this is interfering in the course of justice.
Mr. Chaudhary, if this is done, if that property is culled out from this property and expunged from the hotspot of this property, this will solve half of your problems.
Miller, I am ready for
You can
that.
take out your own partition suit against Mr. Mitra.
I am ready for that. For 3B, we'll take out a partition suit. But only thing is, where Milord, I'll be very candid with your lordships. Milord, I am thinking this way that if Milord that is done, partition commissioner will never be able to put up a wall between A and B because he will come back as owner of B and resist.
There should not have been a mutation then separately. When there is a mutation, Mr. Chaudhary, I don't know whether you know or not, there has to be an inspection from the corporation to check whether these are different properties. There has to be a notional wall at least between the two. I mean, you manage the mutation maybe, both of you, and now you are suffering. For mutation, it has
But
to be
there
seen
has-
whether these are structurally separate properties.
There has to be not an effective remedy to a partition suit. I've got everything. Yes, I accept. Your
But
lordship.
you are the owner, co-owner.
Yes, your lordship restricts it to 3A. I'll start another fight regarding 3B. I'll accept that also. But if I can't even get 3A out of 3B, then where will I be?
No, 3A has to be out. I mean, 3A in the first place, they did rather 3B plaintiff did not have any right in the first place to file a suit.
Yes.
We'll hold that the suit is not maintainable at the behest of the plaintiff in respect of 3A.
In 3B.
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 But definitely it will be open to both the co-owners of 3B to take out a partition suit. Both or
Yes,
either of
very
them.
well, I have no problem. But
You have that right in law.
yes, but 3A must be pursuant to this decree separated from 3B. Otherwise,
They are separate properties.
yes, they are separate, but physically separated. Otherwise, your lordship sees the situation.
In this suit,
Three-
we cannot, there is no scope of
So,
doing that.
co-owner of 3A will file a suit for partition in respect of 3A. Co-owner of 3B will file a
Yes,
suit
because
for
these are two
partition.
different flats.
Then there will have to
separate.
be a third suit.
Mr. Chaudhary, if you are really, if you had genuine interest in your heart, all of you, to conglomerate the property to it, there is a provision, just like separation of a property by mutation. You can also combine properties by mutation. There is a provision in the, before the corporation, you can do that. You can join two properties by agreement. And you can
Yes.
have a separate mutation of that combined
Yes.
property.
Yes.
You could have done that.
But-
Since that is not done till date, now it will never be done because
No,
there
it
is
is because
acrimony
we are not agreeing.
because there is acrimony between the parties. So therefore,
Let me not reconsider this matter once and
Mr.
come back.
Chaudhary, another day wasted behind this would not be
No,
feasible
my
for
lord,
the court.
15 years of litigation. I'll also do some research.
What is the application for?
Application
You come
is-
prepared, then Thursday we are keeping the application along
Yes,
with the appeal.
Yes, yes.
You give
Next week. Out of those 100 adjournments, 62
No. Please see the order of, please see the order of the division
62.
bench.
I can give
No,
days.
please.
Even today.
No.
Even today.
No, wait, let's do the matter.
Yes,
Let's
please do the
matter.
matter.
Yes,
Chaudhary,
let us do that.
don't go into this. This is the precise reason for saying it. Don't act
No,
like
no.
Mr. Shah.
No, let us see.
Today.
Let
He
us,
started off by saying,
let us
that
see.
I will take
Let
action.
us see. Maybe
No,
I'll
he's-
lose.
he
Maybe
is
I'll
actually-
lose. I
Mr.
don't
Chaudhary,
mind.
don't fall for this trap.
No,
Come back another.
Please remember, Mr. Chaudhary.
no, you all.
Another adjournment
No,
next week.
very well. Let us lose. Let us do it. Let us do it.
Besides purpose,
Let
Mr.
us do
Chaudhary,
it.
come back on Thursday.
Let's do the matter.
Come back in better mind.
Let me to take an
Come back on
adjournment.
next Thursday. Today we are on 22nd.
My record.
Come back on 30th April. Very good day. There will be sunshine outside, we hope. And we'll
No,
have
no.
a good fight here.
No, Milord, I just want to show your lordship.
Exchange your
No.
paper.
Wait,
No, Mr. Chaudhary,
Milord, kindly see.
you cannot
one
have your
order.
luxuries with the court. No, we don't have so much time. Either you, if you do the appeal, you have to exchange the paper books today. We'll take up the appeal along with the application today. We'll take up the appeal. Since a brief point,
I'll remember this.
Only one thing,
I'll
my appeal
remember
is
it.
coming tomorrow. That particular appeal may be tagged together and
when it comes to tomorrow, when it comes in the list tomorrow, just mention that
I'll do.
it is also.
I'll be happy if you remember.
I will.
Yes,
What?
please.
I will. There are numerous adjournments you take, and I have a practice of not
No,
opposing
just
them.
give us a list of dates on the next occasion. We'll
Yes, I will give a list of
Give a soft
Not-
copy. We'll copy
not
paste in our
fair on your
judgment so
part.
that it prolongs our judgment and looks good.
Milord, may I give them, Milord, the paper book also? I've prepared it.
You have to. You shall not. May.
Yes.
Since the ambit of the appeal itself is brief, and the comma the owner and the paper books in respect of the present appeal have already been prepared informally by the you are the appellant
Yes.
by the appellant, the learned advocate on record for the appellant shall circulate the copies of the paper books to all the parties during the course of the day. Full stop. The appeal along with the connected application shall be listed together for hearing on April 30, 2025. But it will then go down a bit down in the list.
Or Milord, on the stay petition, your lordship can dispose it of.
Very well. On April 30, 2025, when the matter will be listed under the heading application. Understanding is appeal and application will be heard together. We will be circulating the paper books.
I will also try to prejudice your lordship to
On what?
any benefit which I may derive from the conduct of the defendants in the suit.
That has nothing to do in a civil matter. Unless it's
Yes.
an injunction.
No,
We are not on equity, we are on legal rights.
yes, on legal rights, but
But maybe a bad person may get a good civil degree.
yes, but then I'll try. But
Even a criminal may get a
insofar
very
as
good
that
civil degree.
separation is concerned, if your lordships will not appreciate the futility of 15 years spent, my lord, maybe because of wrong advice.
It is futile.
It
has
is
been
futile, but something I might get out of it.
the best thing you can get out of it is to get out of this suit, because the plaintiff does not have any right to file the suit in respect of 3B. So get out of this suit. Have your own suit against your defense client.
At least for 3A, I'll my lord retain my decree. Partition decree in 3A is 3A. I'll get here.
3A is, I am for the plaintiff, your lordship. My decree is perfectly right, your lordship. I am the
Yes.
owner of 3A.
We are together.
50%.
That's another appeal coming up tomorrow.
You can dismiss that also. No?
No, that look, that your
That
lordship.
will be heard together with your appeal.
Yes. Or we can do this tomorrow also, my lord. And if since it's coming today,
So
we can
in
do
their
it
appeal,
tomorrow.
what is the position? They have not prepared paper books.
No, they haven't.
This
can be-
No, the documents will be common.
Documents are the
All
same.
common.
Documents
So-
are-
We'll hear it on your paper books.
Yes, yes.
Tomorrow, when the matter comes up, you find out whether there is anything missing, because they'll be giving you the paper books today.
No, we are together. We have done it together. There's no difficulty. No, Lord, this is effectively
Then-
father-son.
Then
No
we'll
problem.
we'll
So
direct
tomorrow, my lord.
Tomorrow when it
Equity
comes
law.
up, no, on Thursday.
On Thursday.
30th, when it
I'll
comes up
indicate.
tomorrow, we'll direct it to appear.
Thursday.
30th.
হ্যাঁ, করে দাও।
Next. Another 15 years. This appeal will be kept pending for 15
The
years.
Lordship has admitted the appeal, my lord, and granted an interim order. The Lordship may.
The appeal is against
I'm paying for my lord vacating, my lord.
ad interim injunction was refused.
Lord, there was a stay granted under Order 7 when Order 711 was rejected. They paid for, my lord.
Just give us the entire facts, Mr. Chatterjee, just in a
Fine.
nutshell.
Injunction granted ad interim
Suit for?
for, my lord, declaration of my tenancy right.
Oh.
Well, and permanent injunction, I did not pay for declaration, just for permanent injunction that you cannot throw me out without due process of law.
They are the landlords.
No, they are the bank, the financial institution. I am
Oh.
saying that
You
I
are
am-
trying to obviate the surface proceedings. That is their allegation.
I am saying I am a licensee, you can't throw me out. I am there in the property as a tenant, you can't throw me out, whatever happens, you can't do it without. due
Tenant or
process of
license?
law. Tenant. If I can show that I am
You're a pre-mortgage tenant.
pre-mortgage tenant, if I can show that I have documents to that effect. Court on seeing those documents will have granted an order of injunction. That order of injunction was never challenged, was extended from time to time.
Hmm.
They filed an application under Order 7, Rule 11 in the court below, my lord, which got rejected. Challenging that, my lord, they came up before this honorable court. This honorable court granted stay of all further proceedings in the trial court. In the trial court. Then, my lord, what happens is the trial court says that since there is a stay, I will not extend the interim order.
Against that you have come up.
Against that,
Mr. Chaudhary will dispose of the appeal and can you do that? Stay of hearing, have you got any judgments on that, Mr. Chatterjee? There are certain
I have.
judgments.
I
Stay of
don't-
suit
I
does
didn't-
not mean
I
interlocutory.
don't think it's required, but even
But
for
it's definitely required. Give a copy to Mr. Chaudhary. Argue on that.
but this excuses us because it's a single bench. That's one.
Right proposition, always.
Hey, Tajul. Kindly have a look at paragraph 7. The other division benches, they did not even bother to write the judgment. They said they thought that it was so obvious a proposition that they did not even, there was nothing reported as such on this.
Don't overdo it.
No, I agree with the proposition. I agree wholly with the proposition, but that stay of proceedings in a suit
Yes.
has no correlation to interim relief.
Right.
Lord, in fact, my lord, even if a suit is stayed under section 10, we are entitled to move and obtain an order of injunction.
Precisely. Precisely.
That I have a Supreme
Can he
Court
record
judgment.
his submission, my lord, and grant?
No,
No,
direct?
no. If
No,
that
no,
be
my
so,
lord.
Mr. Chaudhary, what is, because how could the
I
court
will
do it?
just, my lord, I accept that position, but my lord, every order of continuation or passing of an injunction order is a fresh order. I just want your lordship to see one amendment of the Securitization Act, just once.
17.
Section
Surface
17,
একটা দিন না।
subsection 4, capital A.
Sorry, please give the section.
17,
17(4)(a).
4A, where, I'm sorry.
17(4)(a).
May I read it, Lord?
Hmm.
Where any person in an application under subsection 1 claims any tenancy or leasehold right upon the secured asset, the Debt Recovery Tribunal, after examining the facts of the case and the evidence produced by the parties in relation to such claims, shall, for the purpose of enforcement of security interest, have jurisdiction to examine whether lease or tenancy has expired or to determine or is contrary to Section 65A of the Transfer of Property Act, or is contrary to the terms of the mortgage, or is created after the issuance of notice of default and demand by the bank. And if the Debt Recovery Tribunal is satisfied that tenancy right or leasehold rights is secured in secured assets fall under, my lord, then such and such, then notwithstanding anything to the contrary,
The interface.
the Debt Recovery Tribunal may pass such order as it deems fit. Now, important is, my lord, this is after a deluge of cases where
Mr. Chaudhary will tell you this, why we are against what you are trying to propose. You are right, this is provision is there, but this consideration has to be within the broader limits of the powers of the tribunal under Section 17. For adjudicating those things, whatever powers are conferred under Section 17, this can be one of the considerations. This will be one of the considerations if somebody claims to be a tenant, provided the tribunal in the first place has the jurisdiction. Now, please come to 17(2), subsection 2. What will the Debt Recovery Tribunal do? Consider after that application is filed. Shall consider whether any of the measures referred to in subsection 4 of section 13 taken by the secured creditor for enforcement of security are in accordance with the provisions of this act and the rules made thereunder. Nothing else. It cannot adjudicate title, cannot adjudicate the right of a person in a property, the corporeal rights. It cannot do that. So this consideration has to be within that limit. Suppose 13(4) measure is not some provision
I
of this.
accept completely.
See, if that be so, Mr.
Yes.
Chaudhary, the entire conspectus of 17, section 17, is that whether the measures have been taken in accordance with this act or the rules. That is the only thing which has to be seen. They are a pre-mortgage tenant.
What your lordship is saying, no, this is under appeal. I lost here. That's a different matter.
Which is a different matter. That matter is a different, or you lost in appeal. No, Mr. Chaudhary, but seriously, but therefore,
No, my lord, I totally,
and
again,
they claim to be a pre-mortgage tenant.
I again totally agree with what has fallen from your lordship.
How could the court midway? I mean, initially it had granted an interim order of injunction.
That's because stay is there, my lord.
Now, my
That
lord,
is why.
It was vacated because of the stay, which is an entirely wrong premise.
that's totally incorrect.
There was no question of any if you had filed an order 39 rule 4, could be a consideration.
Yes.
Final hearing of injunction, consideration. Appeal, consideration. But this is no consideration.
Order
Midway,
7 rule 11.
ad interim is subsisting. It is not extended probably because of that stay order. That, Mr. Chaudhary, there is
No,
indefensible.
totally wrong.
Cannot be done.
Totally wrong. So, my lord, give me
Yes,
just,
dispose of the appeal.
yes,
This
but-
is the only scope of the
yes,
appeal.
but then let
Write
us,
out
my
in the
lord,
order 7 rule
also
11.
indicate what has happened in the suit. Order 7, Rule 11 was also rejected. Or from rejection, so injunction order granted, injunction order was being continued because suit is not maintainable. We had proceeded
711.
up to, we filed the order 7, Rule 11.
Rejected, you came up in this
Rejected,
court.
revision, stay of all further proceedings in the suit,
That revision is
Where-
still pending. Master.
that is pending. Now, when that happens, the order is communicated to the learned court below. Then the learned court below has, of course, I agree totally that this is an incorrect order because this can't be a ground for not taking up or extending the order. But Order 7 rule, contents of Order 7 Rule 11, the revision application, the order of the High Court, these are matters to be taken into consideration while deciding whether interim order is to be extended or not.
Extension, Mr. Chaudhary, is an extension of
Is a fresh order. Every order of injunction extension is a
we
fresh
have our
order.
differences on that.
That is a old hackneyed Milord.
Not sold, not so hackneyed. Not sold, not so hackneyed.
I am aware of one judgment
Order
which
39
says it's a
rule
fresh
1 and
order.
2, there has
That's
to be a
now being-
consideration under order 39 rule 1 and 2.
That's now being decided, Miller, in the full bench.
In the full bench judgment.
That's
So
debatable and we hold a different view on that.
that it's a continuation of the earlier order.
It's a continuation because it's mechanical in a sense.
But
Because if
Mr.
there is an adjudication while extending,
Yes.
if there is an order 39 rule 4, the entire scenario changes. In spite of that, you have to deal with that and then go.
But my order 7 rule 11 is on
Extension
record.
means the extension presupposes there is an existing thing.
Yes.
Otherwise, every time it would be a new exercise under order 39 rule 1 and
New
2.
reasons,
New identity,
etc.
new reason and new identity order, then all the rigors of order 39 rule 2, 2A, everything would apply. Every time.
Correct.
Every time an extension is given, everything has to be followed again. If you refuse, you have to give
I
reason, everything.
understand and I
That
totally
cannot be a
appreciate.
feasible practical proposition.
But in a situation like this, where your order 7 rule 11 rejection has effectively been stayed by the High Court,
Only
you
ground of not extending is that a stay is prevailing, which is a wrong ground. Therefore, we set aside, we extend the order and we direct the injunction to be decided early. Because this premise of the order cannot be sustained. There was no consideration of anything. I mean,
no, there is.
there was no order 39 rule 4 even. Why should the court consider? Come on. Although we'll remember this proposition the next time you come for an extension of your interim orders in this court.
No, but I am
That's a
conceding.
different thing altogether.
But then I am conceding.
After consuming
Milord,
10
I-
minutes of my
this
lord's
is
time.
Milord, the other thing is
Indefensible
no,
defense.
I understand, but the other thing which Milord strikes at the root of the matter is bank.
So you may have a good case in
No,
this.
no, I have a section 14 order which I am not being able to enforce. A defaulting borrower is on technical issues
That's on the merit.
continuing.
Could have taken out a order 39 and order 39 rule 4. We are not here to advise. You can take
May
out.
I humbly pray for this? Please, Milord, limit a time for me to file
No.
my written objection to
Where?
the injunction application.
Oh, yes, yes, definitely.
And please
Whoever
direct the
wishes to do it.
court
Within
to
a limited
dispose
period.
it off within a month.
That is what we are intending to do. Because you cannot be held up forever on the injunction.
Because ultimately, it strikes at the root
Yes,
of
this
the
has to be
matter
decided
that
in the
these
injunction
games
application
borrowers
subsequently,
play,
yes.
Milord, has to stop at some point. of
Finally,
time.
it has to be decided in the injunction application itself whether the injunction application is maintained.
23 1 ACC.
And also the revisional application also we don't know. We cannot do anything on that.
Milord, I have seen a case, Milord,
But on the injunction, it can be decided also.
even
case by
injunction
case.
application can be brought before your lordship, both can be decided together. The revisional application. No, it used to be done. I have been,
We've done it many times before, but here.
It used to be done before your birth. You have no more.
no, after my birth.
No memory of that. So
No, no, after my birth in one matter. Revision, everybody was there. All the seniors in 2002, Milord, were there. They agreed. Revision
engage all the
came
other
before
seniors. We
appeal
will wait for that. And in this matter, we are
court.
discussing.
Castron mining.
That's what I meant.
Because the seniors were
You're
there, the
kidding.
judge was cowed down and must
No,
have.
no, not a
No, no, it
judge
used
saying-
to happen, Milord, if there was
All
one
the
appeal
time.
and one revision.
Not
filed.
all the time. When alternative revisions were filed.
Yes,
Mr. Chaudhary.
yes. Mr. Dasgupta's favorite thing.
Yes, we had so many scenarios when Mr. Mukherjee also knows, many of you know, you also know.
Hmm.
Because when there is a doubt whether an appeal will lie or a revision
Both
will
were
lie,
filed.
we file both alternatively, both are taken up together so that if one is not taken up, the other can be taken. We used to, in those cases only those that were tagged together, otherwise not.
No,
Separate
here,
revision arising from a separate order, we don't tag together.
No.
We never
same
tag together.
subject matter.
No, not a same subject matter. We never did that. Only when it was an alternative to the appeal.
No, that Castron mining is the only case I am aware of. Otherwise, I have not seen this. But Milord, kindly.
We are recording your consent for taking up the appeal.
Yes, of course. But Milord,
Because otherwise, instead, I mean, what's the use of granting an
but
injunction?
please
keeping it
give me a Milord, direction for
How
this.
soon can you file your objection in the court below?
3
Tell us.
days.
Then filed from 2019.
No,
But-
whenever they can file, it depends on them. And you don't have a right of reply in the trial court. We won't give you a
No, and no adjournments and disposal in a month.
only injunction application, written objection. That is the established
no
practice.
reply.
দুদিনে দিয়ে দেবে?
Whatever Mr. Ghosh may think on that.
দুদিনে
জিষ্ণু
They-
যদি
they- Yes,
দেখতে
Mr.
দুদিন
Chaudhary
সময়
will
লাগে।
file it within 3 days. he's
আমি
saying.
দেখবো না। Milord, by Monday I'll file.
We'll give you 1 week's time.
1 week.
That will be reasonable.
Me 2 weeks.
What me too?
আবার কি?
Me too. You have also have a me too. Anyway,
Me too, we.
in view of the short conspectus of the appeal, comma, on consent of the
draft করেছে,
on
reply
consent of
draft.
what is this?
reply to the opposition file.
Opposition file draft করেছে
On
না?
consent of learned counsel for the parties, comma, the appeal is taken
Settle
up for
করেছে।
hearing along with the
হ্যাঁ, settle করেছে,
injunction application.
settle করেছে।
Full stop, next para. The appeal arises out of an order whereby the learned trial judge refused to extend or vacated, refused to extend an ad interim order of injunction granted in favor of the plaintiff stroke appellant initially on the sole ground that there was a subsisting order of stay of all further proceedings of the suit granted by a revisional court. Push up next para. The short conspectus of the case is that the plaintiff appellant filed a suit for permanent injunction and ancillary reliefs in which an ad interim injunction was granted in favor of the plaintiff stroke appellant, comma, which was being extended from time to time. Push up during subsistence of such injunction, comma, the defendant, both the defendants filed, you are appearing for both the defendants.
One.
The defendant number, you are for two. The defendant stroke respondent number one.
The borrower.
Defendant stroke respondent number one filed an application. Please, all of you take your seats. Filed an application for rejection of the plaint under Order 7, Rule 11 of the Code of Civil Procedure, comma, primarily of the premise that the suit is barred by the provisions of the Surface Act. Push up next para. Upon such application for rejection of plaint being dismissed, comma, the defendant stroke respondent number one preferred a revisional application against the same, which is now pending before the appropriate bench of this court. Full stop. In connection with the said revision, comma, the learned single judge passed an order of stay of all further proceedings of the suit till disposal of the revisional application. Full stop. Next para. When the plaintiff appellant next approached the learned trial judge for extension of its interim order of injunction, comma, the learned trial judge, comma, by the impugned order refused to extend the same, apparently on the premise that in view of the stay order granted by the revisional court, comma, the hands of the learned trial judge were bound and the learned trial judge could not even pass an interlocutory order in the suit. Push up next para. Upon hearing learned counsel for the parties, comma, we find that the stay order granted by the revisional court operated in respect of further proceedings in the double inverted with the suit, and as such could not be construed to debar the learned trial court from taking up interlocutory applications as well. Full stop next para. It is a well-settled proposition of law that the stay of a suit by a superior forum cannot operate as a stay in respect of the interlocutory applications in connection with the suit as well. Full stop. Since the learned trial judge acted contrary to such well-settled legal proposition, comma, the impugned order is bad on such count. Full stop. Next para. Accordingly, comma, FMAT 290 of 2024 is allowed, comma, thereby setting aside the impugned order bearing order number 53 dated March 28, 2024, passed by the learned judge in charge, comma, City Civil Court at judge in charge of the 10th bench of the City Civil Court at Calcutta in title suit number 1448 of 2019 and extending the interim order of injunction initially granted by the learned trial judge till disposal of the temporary injunction application pending before the court below. Full stop. Next para. The since learned senior counsel appearing for the respondent number one submits that the respondent number one seeks to file a written objection to the temporary injunction in the court below, comma, we direct the respondents to file their respective written objections to the temporary injunction application pending in the court below within 1 week from date. Full stop. Next para. The learned trial, in view of the urgency involved, comma, the learned trial judge shall make all endeavor to dispose of the injunction application itself as expeditiously as possible without granting any unnecessary adjournment to either party, comma, positively within 4 weeks from the date of communication of this order to the learned trial judge. Full stop. The parties as well as the learned trial judge shall act on the written communication of the learned advocates for the parties coupled with a server copy of this order for the purpose of compliance without insisting upon prior production of a certified copy. Full stop. Consequentially, can 1 of 2024 is also disposed of. There will be no arrest to cost.
Only one indulgence. If defendant number 2 does not file, that he should not seek an extension. Otherwise, he'll keep.
No, we have directed both of you to file within a week, and the court will dispose of within 4 weeks from date of communication. There is no rider to that if they don't file. Even
is
if
the
you don't
that
file,
is-
it will proceed on the
Yes,
injunction.
I will file,
That,
but
that
I am
without
scared of
granting any unnecessary adjournment, we will put in the word unnecessary because
sometimes it
some
becomes
may
somebody
something
fall
may
sick,
happen.
something may happen.
Yes, but we have given the outer limit as 4 weeks.
Not 4 weeks takes us to summer vacation.
আচ্ছা 4 weeks টা যেখানে বললাম 4 working weeks করে দাও।
Grateful.
Summer vacation trial
no,
court there is no summer vacation but the strikes covered that.
Strikes come. The moment High Court closes, they also will.
Yes,
That
that is a deemed summer vacation.
deservedly so.
Hey, it's
No, I think
terrible.
Absolutely. They deserve it much more.
Yes.
Conditions
Conditions
of
are so difficult.
Conditions of the judges also, they don't have washrooms. You cannot imagine the situation in some districts. Alipur and all these are better.
I think the biggest thing is stenographer
Everything, every piece of infrastructure.
and air conditioning today.
Air conditioning, even the chairs, carpets, you don't know the situation in the district courts. Our little far off districts are worse off.
Very bad.
They are
Cannot even
original side
imagine.
lawyers,
We
sir.
pass
No,
orders in
I
basic
go
court.
all the time. So
Oh, then
They are original side lawyers. Man.
yes, so we have to.
Apply. Districts.
there are no suits better.
Parashat,
Original side
Alipurduar.
lawyers, no suits better than appellate side lawyers
The condition.
by definition.
Condition also with the
Condition they have
original
to.
side. We
That
are
is
also
only
now.
the air conditioned places here, my lord, in the High Court, not in the.
Mr.
No,
Chaudhary knows
Chaudhary,
that.
I'm sure goes in.
No, because
district
now
court.
He
a
goes
lot
to
of,
district courts, but American district court.
Yes.
lot of our
Mr.
work
Ghosh is there since Mr. Ghosh is there.
Please ignore him.
We should ignore him on you.
Worst combination possible.
Yes.
Worst.
Your trio, your trio.
Yes, Mr.
Not only them.
Chatterjee and Mr.
This
Ghosh.
trio is the worst combination possible for the court. We'll come back
Now
after this.
commercial courts we go a lot.
Commercial
But
court.
commercial courts also, I mean, the infrastructure is not yet up to the mark.
Parliament
crores.
করে দিয়েছে commercial board of the court
চলুন কোনোদিন যেতে পারি। So, Madhav, what is the defect? Deficit code fees.
Yes, it has been put in. I have put it.
Deposit, because there was a default clause.
I have put it.
Very. What is the matter about?
Now, the tenants appeal
I did
for
it.
eviction.
Huh? Oh. Seconds. তো করে দিয়েছি সেকেন্ড হচ্ছে ডিগ্রি হবে ও অ্যাপেলের ডিগ্রি ইটস রিটেন ইন দ্য মেমোরান্ডাম অফ অ্যাপিল ফ্রম অরিজিনাল ডিগ্রি উইল গিভ ইউ লিভ রাইট নাও সো দ্যাট ওয়াজ মিসড আউট বাই দ্য ডিপার্টমেন্ট প্রথমেই একটা কি আছে এখন আসেনি কার থাকার কথা আপনারা বলেননি অন্য কাউকে আসছে So let us start hearing it. We'll begin.
Well, tenants appeal suit for eviction, judgment of affirmance. Well,
All the criteria are fulfilled.
yes. But the
What is
notice to quit was returned with postal endorsement, not claimed. That has been accepted as good service, treating the same as refused. I have nothing to say more than this.
No, some office here. So, but when you have the advantage of a short second appeal, the stenographer is not there. ওরা জানে না অনিন্দিতা the leave is granted to the learned advocate on record for the appellant to carry out the necessary amendment to the caption of the memorandum of appeal by describing the same to be a memorandum of appeal from appellate decree instead of from original decree. So, next para. The present second appeal has been preferred by the tenant stroke defendant stroke appellant against a judgment of affirmance whereby both the courts below granted a decree of eviction against the appellant on the ground of default in payment of rent under the West Bengal Premises Tenancy Act 1997, full stop. The defense of the appellant was struck out in the suit under section 7 within bracket 3 of the said act in view of non-compliance of the provisions of sections 7 within bracket 1 and 7 within bracket 2 of the said act. Full stop. Next para. Learned counsel appearing for the appellant argues that both the courts below erred in law in construing the service of the eviction notice on the appellant to be good service, comma, despite the envelope in which the notice was sent having been returned with the endorsement within bracket not claimed, double inverted close, full stop. Next para. However, comma, it is well settled that if an attempt is made to serve a notice on a person and the noticee, comma, despite being intimated, comma, does not claim the said service, comma, the same tantamounts to good service in the eye of law. Pushed up as such, comma, we do not find any irregularity or illegality in the courts below coming to the conclusion that the notice of service, comma, which is the service of notice for eviction, comma, which is a sine qua non for instituting a suit for eviction under the 1997 Act, comma, was correct in the eye of law. Push up. In such view of the matter, comma, we do not find any substantial question of law involved. Push up. Accordingly, SAT 189 of 2023 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Push up. Consequentially, comma, Can 1 of 2023 is also dismissed without any orders to cost. Yes. Thank you. Please, the correction, please.
In this matter, I am for the respondent. Mr. Ganesh Srivastava appearing for the respondent, my lord. Due to medical emergency, my lord, he has not come today, my lord. Make it on Thursday, my lord, because my lord, last occasion.
Thursday appeal hearing day.
Yes.
Thursday is appeal hearing day. I'm just
Thursday appeal hearing matters are taken
My
up.
lord, next week, my lord, because it will be
This is against the grant of
order of remand. Appeal against an order of remand. Trial court dismissed the partition suit. I'm the defendant number 3. The appeal court, Lord, send it back on
What is
remand.
your ground? Main ground?
The materials were there before the first appellate court to decide instead of remanding.
So order for Rule 24 applies. It's a matter of course. We'll admit the appeal and grant a stay of all further
no,
proceedings.
it will be disposed of because, my lord, last occasion, Justice Tanon heard it, my lord, due to some other reason, my lord, it has not been.
There was a direction of this honorable court that I should be serving. Accordingly, I had served. That is what you will find at 1st of April order. Thereafter, my learned friend had appeared on 2 occasions,
yes,
Lord, and the last appearance was on 6th of August 2024, as I find.
Yeah.
And on that day, they also asked for an accommodation.
My
Lord,
learned
I'm
friend
objecting to his
on
accommodation.
that day, he was not there, my lord. That's why, my lord, it was adjourned.
That's why you prayed
So-
for accommodation.
Yes.
So, Lord, I am not, at least on the ground of Mr. Srivastava going to the doctor, Lord, I am not opposing at all.
The appeal may be disposed of on the next day. Yes, what are you saying?
Thursday to
I think so, my lord.
We are admitting it, we are granting stay, keeping the appeal on Thursday. Why do you say that? Because you'll be conceding to the
No. Consider my lord's intention was to hear out
His
appeal and
lordship's
appeal.
intention.
Yes.
not my lord, that lord.
Yeah. My lord, that's true.
No, so intention was to hear. Let us see if that is reflected in the
1st of April,
First of
2024.
all. That date is
Yes,
crucial.
my lord.
My lord, then make it not today only, my lord. I only make it not today.
Try to come tomorrow.
Yes.
Since there is a possibility of the appeal being taken up for hearing immediately after admission, comma, on the prayer of the respondents, comma, who would not otherwise have any right of hearing at the stage of hearing under Order 41 Rule 11 of the Code of Civil Procedure, comma, the matter is adjourned for the day.
Lord. But maybe on Friday, Mr. Bhattacharya is having some difficulty to.
Friday then adjourn for the week. তাহলে ওটা adjourn for the week করে দাও and shall next be listed on April 28, 2025, Monday.
Lord.
কত দেখেছেন? টাকা হয়েছে কি?
Well, for the appellate, my lord.
35, yes.
My lord, tenants appeal, my lord, but judgment of reversal.
আচ্ছা।
Now, my lord,
Judgment of reversals are better judgments.
yes,
The
my lord,
appeal court had to work on the.
my lord, what happened, my lord, the case of the plaintiff is that,
There is no caveat in the.
yes, there is caveat. There is caveat.
Somebody appeared. Parthopratim Roy appeared.
Let me first cross the hurdle of order 41, my lord.
Let us hear you.
I
Yes.
don't think, my lord, the thing is, my lord, the case of the plaintiff is that he
You are the defendant. Suit for eviction.
eviction on the under the reasonable requirement and default. Now, my lord, at the time of my lord argument, default was not pressed. So, my lord, the appeal court has only passed, my lord, or on the ground of my lord, the reasonable requirement.
Both the courts.
Reversal,
reverse,
dismissed.
right.
Dismissed. My lord, the ground of dismissal was, my lord, if the plaintiff used to run, my lord, the hardware business from the suit property. For 13 years, he was not, my lord, running the business. Why? Because his wife was earning. Now, my lord, wife has retired, and my lord, the pension is not sufficient to maintain both of them. Now, my lord, I was given on rent. Now, my lord, after 13 years, my lord, he filed the after I was.
You are given on rent during the period when the wife was earning. So now the wife has stopped earning. I mean, the payment
Yes,
is
after-
meager, and
Yes.
he wants, that is a requirement
That is
for
the
running a
requirement.
hardware shop.
Yes, a court holds that now my lord, the landlord is 70 years old. He is not expected to start a new hardware business after 13 years.
Trial court held that.
Trial court held that and dismissed it. My lord, appel court says no, it's the landlord's
His
choice.
age has increased now.
Yes. my
So now it is what?
1 year, 71. Now, my lord, one thing, my lord, if your lordship would kind enough to see the plaint.
What is the best point?
1B.
May I interfere, my lord?
No, don't interfere. We'll dismiss the appeal probably. Yes.
My lord, plaint, my lord, 61D, my lord, this is the best.
Mr. Roy is in court. Mr. Pat, he is in court in the court building. Very well. Take your seat.
My lord, one point I could, my lord, find out, my lord, in case of 61D, my lord, reasonable requirement, there has to be an averment in the plaint that there is no other, my lord, reasonable requirement within that municipality or within 10 kilometers of the suit
No,
property.
averment needs to be there. 620 does not say that any averment is to be there in the pleading. That has to be established. Did you take any point there is alternative accommodation?
If your
What is
lordship-
adjudicated?
Yes, my lord, kindly.
If it's adjudicated, then
No, adjudicated, my lord, the court said that I could not show evidence that there is, he has any alternative accommodation. But
we'll record your
I'll,
submission.
my lord, on the basis of the plaint has to record, my lord, has to.
Not readiness and willingness.
is
Now,
not-
even that is probably not required to be there in the pleading. Anyway, 620 does not say that it has to be in the pleading.
That is a ground. But
The
for
ground-
for that, the basic pleading has to be
We'll,
there.
we'll deal with that, right? Thank you, Mr. Ratkar.
Otherwise, nothing.
The present appeal has been preferred. The present second appeal has been preferred by the defendant stroke appellant against a judgment of reversal. Full stop. The eviction suit was filed by the plaintiff respondent both on the ground of default in payment of rent and reasonable requirement. Full stop. However, the ground of default did not materialize, being not pressed ultimately. Full stop. The learned trial judge refused to grant an eviction decree on the ground of reasonable requirement on the premise that the appellant, plaintiff respondent is of about 70 years of, of about 70 years of age at that juncture, and it would not be possible for him to start a new hardware business, which was the basis of the reasonable requirement. Full stop. It is to be noted here that the
And which was abandoned by him 13 years
yes, we'll also. It is to be noted here that the plaintiff had claimed reasonable requirement for the suit premises on the ground that although he used to run a hardware business from the premises 13 years back, since his wife had been earning sufficiently from a service in the interregnum, he had stopped the business, being not in requirement of additional money. Full stop. However, upon the wife of the plaintiff having retired subsequently, the plaintiff uh, requires the suit premises for recommencing his hardware business, in respect of which he had previous experience. Full stop. Next para. The learned trial judge also recorded, apart from the advanced age of the plaintiff, that since he had abandoned the said hardware business previously and had inducted the present appellant, the suit could not be decreed on the ground of reasonable requirement. Push up next para. The learned first appellate judge reversed such finding and proceeded on the premise that in view of the retirement of the wife of the plaintiff, and since according to the plaintiff case, the earning from her pension was meager, the plaintiff sufficiently required the suit premises within the contemplation of section 6 within bracket 1 within bracket small d of the West Bengal Premises Tenancy Act 1997. So next para. Learned counsel appearing for the appellant argues that in the absence of any specific averment in the plaint as to the plaintiff not having any suitable alternative accommodation than the suit premises and his present accommodation, the learned first appellate judge erred in law in granting a decree of eviction, since such an ingredient is a sine qua non for grant of eviction on the ground of reasonable requirement under the said provision. Full stop. Next para. However, we do not find any merit in such argument, since section 6 within bracket 1 within bracket small d merely provides one of the grounds for eviction under the 1997 Act and also stipulates that in the event the landlord has an equally suitable alternative accommodation, no decree for eviction on the ground of reasonable requirement can be passed. Full stop. However, neither in the said provision nor within any other portion within the four corners of the 1997 Act is there any mandate cast upon the plaintiff landlord to incorporate a specific pleading to the effect that the plaintiff does not have any suitable alternative accommodation in his plaint. Full stop. In such view of the matter, and since the question of alternative accommodation was raised and decided in the suit and the appeal by holding that the defendant appellant has failed to prove any alternative accommodation of the plaintiff, we do not find that any question of law, let alone any substantial question of law, has been made out in the present case. Full stop, in such view of the matter, comma, SAT 264 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 is also dismissed. No arrest to cost. Thank you, sir. Thank you for being precise.
To appear for the appellant, my lord.
What is the defect on the
Defect,
last
my lord, I
motion?
believe the in the certified copy of the decree of the order of the learned trial court has not been furnished. And my lord, more importantly, my lord, this is an appeal, my lord, from an order of reversal, from an appellate order of reversal of an order of injunction. The second appeal is from an order of, my lord, reversal of an order of injunction. So, my lord,
Reversal of an order of injunction.
injunction order passed by the first court, the trial court.
So revision lies of this. Since the present appeal has been preferred against the reversal of an order of injunction in a miscellaneous appeal, and as Order 43 of the Code of Civil Procedure does not permit a further appeal from an appellate order passed in respect of an injunction order, comma, the said appeal is the present appeal is not maintainable in the eye of law, full stop. Accordingly, SMAT 2 of 2025 is dismissed as not maintainable with liberty to the appellant to prefer a properly constituted and appropriate challenge in the eye of law before the appropriate court against the order impugned herein. Full stop. The learned advocate on record for the appellant is granted leave to take back the certified copy of the impugned orders upon furnishing photocopies of the same for the records. Full stop. Next para, Can 1 of 2025 is also dismissed as not maintainable in the light of the above observations. No arrest to cost.
My lord, the limitation, the time lost, my lord, in pursuing the appeal.
We cannot do anything of that. If Section 14 is applicable, it's not applicable. You are sufficiently conversant with the law. But if it is applicable, it is for you to argue before the 227 court.
Deeply understood.
Thank you. Next. Yes, Mr. Boss.
But this is that matter which was defective initially because it was a RERA appeal.
Oh, yeah.
My
Now
lord,
SMAT.
It has been corrected and it has been set right.
Right.
Well, the appeal has not yet been admitted. There are points of law. May I just tell your lordship the facts?
RERA appeal, we have to go by Section 100 standards.
Yes.
Under Section 58. So
Section
you have
50.
to convince on substantial question.
Yes.
Wait.
Well, the substantial question of law, I've prepared a rough grounds, my lord, but I'm not handing over that to your lordship. In case my lord so desires, I have a suggested issue which I shall give. But let me first tell your lordship the facts. Well, the impugned order is dated 20th of September 2024, passed by the appellate authority.
Suppose please give us half a minute. Hey, shunun, buchi, RERA Act.
Lordship's officers
Yes,
to get
yes.
it.
On the last occasion that happened. Thank you, Mr. Bose and Mr. Dutt. Yes, we have got it.
Well,
Yes.
the impugned order is 20th of September 2024, passed by the West Bengal Real Estate Appellate Tribunal. Now, my lord, what happened was this: I'm a bank. My lord, I gave a loan, my lord, to the respondent number 2, who is a builder. It was to the extent of 600 crores. As and by security to the loan, my lord, flats which were being built by them were mortgaged in my favor. This was done, my lord, by a registered mortgage deed, which is dated 10th of June 2019. Now, the particulars of these flats are given in a schedule which forms part of the mortgage deed. Now, my lord, under the terms of the deed, my lord, they cannot really deal with or dispose of the flats which are mortgaged to us. They also cannot sell the flats without a no objection certificate from us, and the money has to be routed through the bank. Now, behind our back, my lord, some flats were sold after the execution of the registered deed of mortgage. The real estate owner, my lord, did not do anything about it, kept it a secret and suppressed the matter from the buyers. The buyers also did not really carry out the due diligence searches. But that is neither here nor there, my lord. The bank is no way to blame here, and there is no question of fraud on the part of the bank. But my lord, what they did was they did not really give the money back to the bank, the money which they used for the purchase of these flats, my lord, to the bank. And my lord, the account became NPA. We sought resort, my lord, under the securities Securities
The SARFAESI Act.
SARFAESI Act.
Yes.
And also, my lord, moved an application under the debt recovery, before the debt recovery tribunal, receiver was appointed. Now, initially, my lord, what this flat owner did, he made an application before the DRT, my lord, for the purpose of getting that order vacated. Seeing that, my lord, perhaps there was no hope there, approached the RERA. Now, there are certain sections in the RERA which does not empower the RERA, my lord, to pass any orders involving the bank. I can show the sections to your lordship later on as the need arises when we are going into the appeal proper. In spite of that, my lord, an order was passed, immediately release the flats, and the receiver is to give up the possession of the flats. Now, my lord, what was relied on before the RERA court were two judgments, one passed by the Rajasthan High Court and one the Rajasthan High Court judgment was carried to the Supreme Court. Supreme Court, my lord, affirmed the decision of the... And there it is said that if there is a conflict between RERA and SARFAESI, SARFAESI will prevail. But that, my lord, RERA will prevail. But, my lord, what has not been taken care of in any of those judgments, which is the single most important factor in this case, is that mine is a registered mortgage deed which was executed, sealed, much prior to the sale. Much prior to the sale. That is a very important fact which your lordship will have to take into consideration. And secondly, my lord, there was no fraud involved insofar as the bank is concerned, because the bank is playing a straight game. Therefore, imagine, my lord, the situation of the bank now. I have this estate developer. He owes me 600 crores of rupees. He will not return the money. He's not supposed to sell any of the flats. He sells the flats, doesn't give me the money. I declare him to be, my lord, a defaulter. And then, my lord, I have no means of recovering the money, because RERA says that no, you cannot do so. You cannot appoint a receiver. The receiver is to give up possession, etc., etc. I preferred an appeal. The appellate authority of RERA, my lord, reiterated the same view. Now, in this background, I humbly submit, my lord, this is a fit case where the appeal should be admitted, because my lord will have to consider whether RERA has any applications and whether, my lord, the cases which were decided before the Rajasthan High Court and affirmed by the Supreme Court are distinguishable on the basic fact, A, that there was no fraud involved so far as the bank is concerned, and B, the fact, my lord, there is no conflict between the two statutes. There is absolutely no conflict between RERA and SARFAESI in a situation of this kind under Section 88, which says, my lord, the provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force.
But that must have been taken into consideration by the Supreme Court.
No. That is something which we will invite very humbly and respectfully your lordships to
Why
consider.
do you say there is no conflict between the two acts in your case? Because it's a registered mortgage entered into prior to the sale? Why do you say that?
Well, because the mortgage deed clearly says that these are certain things they cannot do. And they do precisely that. And my rights, qua SARFAESI Act, is taken away by RERA, when RERA itself, under certain sections, my lord, doesn't even have the jurisdiction to pass any orders so far as the bank is concerned. I can show your lordship
So please show us those sections.
Yes, I should show your lordship the sections. $31. Kindly come to section 31 first.
Yes.
Any aggrieved person may file a complaint with the authority or the adjudicating officer, as the case may be, for any violation or contravention of the provisions of this act or the rules and regulations made thereunder, against any promoter, allottee, or real estate agent, as the case may be, not bank. Explanation. For the purpose of this subsection, person shall include the association of allottees or any voluntary consumer association registered under any law for the time being in force. The form, manner, and fees for filing complaint under subsection 1 shall be the same as may be prescribed. Kindly come to 35. I'm just showing you, Lordship, my Lord, the relevant sections, which
This is an overview of the relevant.
35, where the authority considers as expedient to do so on a complaint or suo motu relating to this act or the rules or regulations made thereunder, it may, by order in writing and recording reasons therefore, call upon any promoter or allottee or real estate agent, as the case may be at any time, to furnish in writing such information or explanation relating to its affairs as the authority may require, and appoint one or more persons to make an inquiry in relation to the affairs of any promoter or allottee or the real estate, as the case may be. The question of bank doesn't come in here at all. 37.
You are not acting against the respondent number 2 in his capacity as a promoter or allottee or real estate agent, but as a borrower.
As
under
a
the
borrower.
SARFACE Act.
Absolutely.
So just because he's a promoter does not mean that any and every case against him has to be filed under the RERA Act.
Absolutely.
He was not acting in the capacity of a promoter in your case.
No. But
he was just a borrower vis-a-vis the bank.
Yes, it was just a borrower-lender relationship. And when, my lord, certain flats were mortgaged in my favor by a registered deed, and the particulars of the flats are mentioned in a schedule which is annexed to the mortgage deed, and it is those very flats which are being sold. Well, surely I must have recourse to some relief somewhere, and RERA cannot step into the picture.
So this is, and why do you say no, because of no fraud? Because RERA contemplates fraud coming into play.
Whether in the judgment which was relied to,
in the
relied
judgment.
upon. Yes. If
Do
you
you
wish,
have- can you have-
yes. এটা তো সর্বনাশ আমারটা তো মার্ক করা
একটা copy আছে? Any particular paragraph?
Yes, my lord, we seem to have run short of a copy.
No, need not. Give us the
I'm
paragraph.
very sorry, ma'am.
Page number 36 or 60.
Kindly come to internal page number
36.
36. Rajasthan. 36.
Internal page number 36. According to the allottees. Is according to the.
Well, in middle paragraph,
yes,
it appears that allottees had taken loan from, my lord has found the paragraph.
Yes.
It appears that allottees had taken loan from ICICI Bank against the allotment of flats on the strength of tripartite agreement. Resultantly, the security interest in favor of ICICI Bank was created. The same was also registered with the Central Registry of Securitization, Asset Reconstruction and Security Interest of India. Despite this, according to the allottees, developers had taken a loan of 15 crores from Andhra Bank, which is now merged into Union Bank of India, the present petitioner, by creating a mortgage in favor of the bank. This was done order about 4th June 2016. According to the allottees, this was done without verification of existing charge. Without verification of existing charge on the properties in question. The allottees therefore alleged before RERA that such loan was sanctioned wholly, fraudulently, and with malafide intentions.
It was a case where the loan was taken subsequently.
So the loan, my lord, was taken subsequently. In the meantime, since the developer failed to repay the dues to the bank treated the account as NPA and tried to recover its unpaid dues by resorting to provisions of SARFACE Act. Some of the allottees approached the DRT and thereafter DRAT to prevent the bank from auctioning the properties, and thereafter approached RERA for taking suitable action against all concerned, including the bank.
Please give us half a second, sir. Admitting the appeal, sir.
I'm very grateful.
On these two grounds for the time being,
Would my lord
one
be-
ground will be that whether RERA applies at all, because it
Yes.
applies only against promoters, allottees, and real estate agents, and between you vis-a-vis the bank, the relationship is not that of a borrower.
Well, will it be my lord's pleasure if I just, for your
Yes,
lordship's
please
kind
hand over those.
suggestion-
Yes.
My lord, this is not being
No,
audacious.
no, no, no.
or
Please do, please do, please do.
It may be a little cumbersome, my lord.
No, no,
It's
not at all.
entirely up to you. how
Not
your
at all.
lordship
Not at all. Not at all.
frames it.
The stay application is from a subsequent order because in a subsequent order proceeding relating to the same project. Because there are wanted decision is now being passed by RERA in similar line. Or it's the same line. State according
We're choosing from this and this formula.
Entirely up to my lord.
The
Kindly, my
present second miscellaneous appeal shall be heard on the following substantial questions of law. 1. Whether, comma, in view of a registered mortgage having been created between the bank and the respondent number 2 stroke developer much prior to the disputed sales, comma, the provisions of the RERA full form ta pore diye din, apply to the instant case in derogation of the provisions of the SURFACE Act. Next, whether, comma, in view of the relationship between the bank and the respondent number 2 stroke developer being that of a creditor and a borrower within the contemplation of the SURFACE Act and not in the capacity of promoter, comma, allottee or real estate agents, comma, the provisions of the RERA would apply in the present circumstances at all. 3 হচ্ছে whether the whether both the forums below, both the fora below substantially erred in law in applying the principle laid down in the, what is the Supreme Court judgment?
My lord, the Supreme Court judgment is with me. Live law. My lord, this one.
In relying on the judgment of the Honorable Supreme Court in the matter of Union Bank of India versus Rajasthan Real Estate Regulatory Authority and others to hold that the provisions of the RERA prevail over those of the SURFACE Act, comma, in view of there being no conflict between the said two acts insofar as the facts of the present case are concerned. Any interim application, Mr.
Yes. My lord, I tell your lordship what
Now
has
we have to
happened.
hear them, yes.
Yes. No, my lord, I tell you, I'm sure my learned friends are reasonable enough to understand. 88 similar cases are pending. People take the loan, they will
Yes.
not repay the loan, and then they will sell the flats
in connection with the same project.
in connection with the same project. So, my lord, I was humbly praying if there could be an order of status quo. There is a reason for that, because in the meantime, what had happened was, my lord, there has been a subsequent order where, my lord, because the appellate authority, my lord, had refused to grant any stay, 5 lakh costs have been imposed on us. Now, we took out a writ application against that order. But the writ court, my lord, heard us in great detail, but on hearing that the appeal is pending, and if the appeal is admitted, there might be a conflict, my lord, chose not to pass any order. It has been expressly recorded that the writ court is not interfering because of the pendency of the appeal. All that I'm saying is nothing has happened in the meantime, in the sense these possession has been continuing, and these sort of cases are multiplying by the day. If an order of status quo is passed, then, my lord, we can come back on any day subject to my lord's pleasure, my lord, and my lord can hear on the appeal and finish it once and for all. Otherwise, my lord, the stay is very important, because otherwise, my lord, such cases will keep on multiplying, and we will have to come up with a fresh case every day.
Where is the ordering portion of the first forum? Just let us check that.
My lord, the ordering portion,
Probably at least 216.
131.
What was the interim order passed by the regulatory authority? In the
Yes, my lord, I tell your lordship. Affidavit service আমার কাছে রয়ে যাচ্ছে।
Page 146.
My lord, page 146 of the stay application is the first order from which the appeal was preferred.
And the operating portion was 154.
And the operating portion is on page 154. Therefore, I'm sorry, page 150.
Yes.
Therefore, this is the first order against which the appellate authority affirmed this order. Therefore, after hearing both the parties, the authority is pleased to give the following directions. The respondent, Yes Bank Limited, is hereby directed to stop all the proceedings, including notice for auction scheduled to be held on so and or any future date with respect to the scheduled property, that is flat number 3B, block D on 3rd floor, till the disposal of this matter or until further orders, whichever is earlier. An order of stay is hereby imposed upon the notice issued by Yes Bank dated so till the disposal of this matter or until further orders. The receiver appointed in the instant matter is hereby directed to refrain from taking any further steps in connection with the subject matter. An order of stay is hereby imposed on all further proceedings by any concerned in connection with the possession of the complainant and the subject property till the disposal. Bank is restrained from doing anything. 600 crores is due to the bank. The respondent bank is also directed to take necessary steps to vacate the physical possession of the flat being flat number 3B. The complainant is directed to submit his total submission regarding his complaint petition on.
But Mr. Bose, this is in the nature of a restraint order. If we grant a stay of this at this stage, that would be amounting to allowing the appeal.
Some sort of, because
status quo would operate against you also. Status quo would not help you because that has been granted only.
Bank will also not take any coercive steps.
For sure.
That is what has been granted.
Yes.
You are asking for them not to deal with the property in the meantime.
Well, they are not. Well, we are.
Because they have not asked for injunction. They have asked for a stay in this.
Yes, we've asked for a stay for the simple reason, my lord, after the receiver took possession, they have also not taken any steps all this
But
while.
if you grant stay, Mr. Bose, you can understand the consequence. At this stage, you will be able to, it will be open to you then to proceed with the auction
my
sale
lord will
notice
make it clear.
everything.
My lord will make it clear we will not proceed with the auction sale.
Status quo is on.
The status quo is on date. Status quo is
Status
on
quo, you
date.
can pass on an injunction application. Have you
See
made
the
the
bread.
necessary averments?
No, please.
There also we can mold, but let us see whether there are the averments regarding injunction.
Kindly grant us a moment.
Yes, because these are all, there is no threat of anything being done by them at the present moment. The effect of this order is that you cannot proceed with the property with the notice and the
My lord, the order is,
lift that
may
then
be graciously pleased to pass an order staying operation of the orders of the learned RERA, that is the appellate authority under the learned appellate tribunal under RERA, and to grant an order of injunction restraining the learned RERA under the learned from taking up proceeding the complaints appeals
that is
on the
that is in the
same
nature of a
question
stay
of-
also. That injunction is against the tribunal. That
The
means a
point
stay.
is, my lord, I'm inviting your lordship therefore to mold the relief and pass an order of
But
status
there has to
quo
be
so
an
that-
averment that they are doing something regarding the property because the order which has been passed,
My lord, kindly come
by
to
that order
paragraph-
you have been restrained, a restraint order against you.
Kindly come to paragraph 19. Page 9. In the meantime, the respondent number 2 and the appellate bank, after prolonged discussions, have agreed for a settlement outside the court. However, in spite of specific submission being made on behalf of the appellate bank as regards such development, the learned RERA and learned appellate authority have been pleased in passing various orders on the application of the home buyers on the identical ground as the ratio of decision which has been under challenge in the instant appeal. And in the facts of such development, it is imperative to pass an order of stay by this honorable court in respect of any application till the question of law is raised herein before this court is.
Mr. Bose, this will be like passing an order of stay of all further proceedings of a suit in an appeal against an injunction order.
My lord,
Let
but
them not
here,
ask for the
So there is nothing to prevent the RERA from proceeding, and you can always take
Let
a
them-
jurisdiction point there.
Let them not then, at least, my lord, let them not deal with these flats in question, which are the subject matter of
There is not a
proceedings.
single averment in your entire application regarding that they are trying to do that. That is precisely, we can dispose of the stay application without granting any relief, but grant you liberty to file a proper injunction
But the
application.
difficulty is we have been asked, my lord, to restore possession back to them today, unless my lord gives us an order.
Where
of
is
stay.
that?
Oh, yes,
Last part of the order.
the last
Same
part of the order, the same order which I placed just now.
That part we can
Page.
definitely.
That is the part which we
Yes,
are,
yes,
which
that-
we are
that-
most aggrieved by.
Page 154, yes.
E,
Yes. Respond back to your-
vacate the physical possession of the flat, sir, and deliver it to the complainant within 7
Oh,
days from the
this
date of
this
receipt.
portion will stay.
Yes, that is the only
Very well.
portion.
Yes, Mr. Chaudhary,
Yes, ma'am.
regarding E only, page 154.
Lord, please consider in any Milord big real estate, this is Milord ideal group, Milord. The developer Milord is ideal group or somebody who is in a terrible financial condition.
Yes, thanks for the
We have
confession.
absolutely no idea of that.
Yes, Milord,
My lord, we have done matters before your lordship against the ideal group also.
ideal.
That is the reason for their going bankrupt.
I don't. I
No,
don't
my lord.
know. They came and
You
said,
can understand
No,
they're
the-
bankrupt by
the
the set
reason-
of counsel also.
Yes. The reason for saying it, Milord, is I want to make
No,
Milord a
only this
point
portion,
here.
Mr. Chaudhary, we are making it clear. We won't pass any restraint order apart from E at page 154, which says that the respondent bank shall vacate, shall take necessary steps to vacate and deliver to the complainant. That portion is a positive direction, mandatory direction.
Yeah, I just say this.
Yes.
Number one, these are construction loans given by the banks to Milord, the promoter, for the purpose of construction of the property.
Yes.
Promoter is permitted to Milord allot properties to third parties. Bank is very well aware of the fact. They may have given 600 crores, they may have given 6,000
But
crores.
in that registered mortgage deed, there was a restriction.
Yes, but subject to on what terms they have been allowed. Milord, please see clause 5 of the mortgage deed. Lordship
that?
has seen, Milord, clause 5. This is Milord, page 15. Is the mortgage deed. Please see clause 5. Milord, firstly, Milord, 25.
28 is clause 5.
yes.
Milord, we are looking at can one, Milord. In any case, Milord,
Clause
internal.
5 starts with agreed and declared by and between. You can read out clause 5.
Yes, Milord, I'll do that, Milord. One of the conditions for granting the said facilities is to secure
And that is not clause 5.
That is the recital.
Acha, acha.
Let me see this, Milord.
All right, very well, very well,
Yes.
very well.
Milord, it is.
Yes, one of the conditions.
It is. That's Milord before this.
Yes, we have got it. Clause 5, please place it. One of the
Now, Milord, please see 28.
No, first let us
I'll-
complete this
Yes.
page 25.
One of the conditions for granting the facilities and to secure repayment of the amounts due and payable under the said facilities together with interest, cost, charges and expenses is that the mortgagor shall execute a mortgage on the mortgage property which shall stand as cross collateralized against security of the facilities and would not be released until all dues, charges, interests are paid by the borrowers against the said facilities or any subsequent renewal or enhancement of the facilities. So, Milord, with mortgage on the property, repayment is from Milord, sale, etc., whenever it comes to that.
Yes.
Now, Milord, kindly come to page 26. 6,600,000,000. I believe it's Milord 660 crores. 660 crores given.
Yes.
Please, Milord, turn over to page 28. It is hereby agreed and clause 5. It is hereby agreed and declared by and between mortgagor and mortgagee that until default shall be made by the mortgagor in payment of the said mortgage debt with interest thereon or any part thereof, the mortgagor shall remain in possession and receipt of the profits of the said properties, and that the mortgager shall, while in possession of the mortgage property as aforesaid, have no power to make any leases, conveyances, transfer of any interest hereof whatsoever at any point of time after the execution of this indenture, and any leases, conveyances, transfer of any interest hereof made in contravention of this indenture, same shall be void ab initio. Then 7 except 1, with the previous consent in writing of the mortgagee. 2, for such period and on such terms and conditions as mortgagee shall in its absolute discretion think proper.
Mortgagee.
Mortgagee. Now, thereafter, this loan, my lord, is
This is
given.
clear, very clear. You cannot do
Yes, very
anything.
clear. That's why I wanted to read it. So, my lord, it's not that it's mandatorily in writing. Mortgagee in whatever for such on such terms and
So these
conditions.
are and, the conjunction is and.
Yes, and
Previous consent in writing.
yes, and 2.
And for such period as
Now,
they
after
their
this,
absolute
now
discretion.
after this, hundreds and thousands of flats are, my lord, sold to home buyers. Bank, my lord, doesn't object. Allotee, my lord, the allottees go to RERA. Because the bank now what has happened is this ideal has taken my money. I'm an allotee. He's taken my money. He's taken the money of hundreds of thousands of people. And he's taken money from the bank. And today the situation is the bank and I are fighting. He's taken money from both. Milord, there is normally, Milord, there is an equity in favor of a bank. Here there is equity in favor of me also. Now, Milord, please see. Also, my lord, very important fact your lordship will consider. Bank lends money. Projects, my lord, keep coming up. My lord, allotments are made. Agreements are executed. My lord, people are put in possession. Bank doesn't say anything for years. Now, please see, my lord, the section of the RERA. Just one, my lord, provision. Yes, my lord. I'll just, my lord, place the definition of allotee first and then of promoter. My lord, 2D. Allotee
Yes.
in relation to a real estate project means the person to whom a plot, apartment, or building, as the case may be, has been allotted, sold, whether as freehold or leasehold, or otherwise transferred by the promoter, and includes person who subsequently acquires the allotment through sale, transfer, or otherwise. Now, what happens is, when Milord Bank enforces powers under SARFAESI Act, it becomes entitled, Milord, to possession and entitled, Milord, to transfer the property. That second, Milord, your lordship will see that the definitions of promoter and allotee kick in, and it comes within the ambit of the act. This is, Milord, the situation. We can show section 15. There is a
No,
Rajasthan High
vis-a-vis
Court.
the bank, the developer is a borrower.
Yes.
That was the pre-sale mortgage. So it is not that subsequently, because in that case also the judgment cited the referred
That
to
is post. That is
and
post.
that was the premise that fraudulently after the sale loan was given, thereby encumbering the property.
And
that was a clear case of fraud.
RERA,
Obviously, RERA
and
applies.
RERA has a restriction
Yes, yes.
which says that after you allot, you can't mortgage the
It
property.
was the other way around in your case. You were the beneficiary of a wrong act. Wrong act we cannot say conclusively now.
But there is one distinction.
Because there was a restrictive clause in that mortgage deed as you read out, 5, the second
Yes.
5. And despite the in the teeth of that, they have transferred to you post-mortgage.
Correct.
So it's the other way around, Mr. Chaudhary. You are the beneficiary of that wrong act of the developer.
Or the
I can sympathize with you, but your remedy may lie against the developer also. But you are the beneficiary of a wrong act of the developer in the teeth of that clause, restrictive clause.
My lord, question is, my lord, if your lordship sees, my lord, my lord, kindly let me read this once more, my lord. Just once more.
Yes.
Allottee in relation to a real estate project means the person to whom a plot, apartment or building has been allotted, sold or otherwise transferred by the promoter. So, my lord, three things: allotment, sale or transfer by the promoter, and includes a person who subsequently acquires the allotment through sale, transfer or otherwise.
Mr.
So
Chaudhary, we
is he
cannot,
getting it? Is the bank getting it subsequently?
we cannot go by the definitions only. We have to go by the scope and ambit of this act, which has been rightly placed by Mr. Bose, which is epitomized in section 31 and 35. Please come to section 31. What is the
Yes.
scope of this act?
No, I am saying even otherwise.
No, that is on the definitions.
Yes.
But definitions do not serve our purpose. We have to see the ambit of this act.
Right.
Please see section 31. It's between the promoter and the allottee we can understand.
Correct.
Any aggrieved person may file a complaint with the authority or the adjudicating officer, as the case may be, for any violation or contravention of the provisions of this act,
Yes.
or the rules and regulations, as the case may be. Now, bank cannot be roped in because bank has taken out an independent SARFAESI proceeding against its borrower.
Bank has a yes.
SARFAESI Act provisions. Now, therefore, you cannot rope in the bank within the conspectus of
But
this.
if bank becomes an allottee,
Bank, how can a bank become an allottee?
that's why, my lord, anybody.
It was a prior mortgage, Mr. Mr. Chaudhary.
Yes, but when you do
There was a mortgage in their favor,
correct.
which restricted the developer from selling. You are you are taking advantage of that sale.
My lord, it's a valid mortgage.
Mortgage is valid. Your sale is not.
My lord, if the mortgage, the question of whether my sale is valid or not comes secondary.
Rather, your purchase. Yes.
Yes, my purchase comes secondary. It comes later.
But if that
is-
does not come in, you cannot invoke this act in derogation of this
No,
SARFAESI Act.
but does he come in within the definition of the RERA? That's the first question. Answer is yes.
Why?
Because, my lord, if your lordship sees the definition of allottee, he, my lord, the second he enforces his powers under SARFAESI Act, under section 13(4), he acquires the right to the property. The second he acquires the right to the property, he, my lord, becomes an allottee. And then he comes into the ambit of the act. Other questions are later.
He is not a subsidy. The bank is not a subsequent allottee. Bank had a prior right and encumbrance on the property. So it's not a question of the bank becoming an allottee. An allottee is to whom an apartment or real estate project has been. They were there in the picture prior to the building even coming up.
No, they are there in the picture. They've given a valid mortgage.
Gave the loan with that the property came up. So therefore,
Well,
they
there's
cannot
no
be.
problem. But question
It's
is,
not an allotment of any of the flats to them.
no,
They had a prior right on this entire property
they
as
had
a
a prior
security.
right on the property.
They're not
Now
an
the
allottee.
question is
It's
that
very far-fetched. Allottee, calling the bank an allottee in
no,
the facts
as
of
per the
UAP is-
definition, they'll fit in. There are other lot of law to be cited here. When bank
But
today,
they cannot be. We cannot permit them to be compelled to vacate the flat and give
very well,
possession
let
to
both
you.
parties, my lord, let them also not take steps and under SARFAESI Act. That
We are not. We don't get us. We refuse Mr. Bose's prayer of a blanket stay on this entire order. Please come to page 154 once.
Very
Please come to page 154. That will answer your queries
very well.
and Mr. Datta's queries also.
Yes, E will be stayed.
Only E, and we are not staying deliberately the other portion. See the other portions.
Yes.
All those restraint orders against the bank, if we stay those, that will be allowing the appeal.
Very well.
We cannot stay those. We are not staying those. The application we find from the impugned orders that the majority of the directives given thereunder are in the nature of restraint orders, which, if we stay at the present moment, would tantamount to allowing the appeal before it is heard out on merits. However, insofar as clause small e of the first forum of the order of the first forum is concerned, By virtue of the same, comma, the respondent bank has been directed to take all necessary steps to vacate the physical possession of the flat, being flat number 3 capital B block hyphen D on the third floor of the subject matter project and deliver it to the complainant within 7 days from the date of receipt of the said order of the authority through email. Full stop. Next para. Unless the said portion of the order, impugned order of the first forum is stayed, comma, the appeal might be rendered infructuous and the appellant bank would suffer irreparable injury. Full stop. As such, comma, we grant stay of operation of the portion of the impugned order of the first forum dated June 24, 2024, passed in complaint number WB RERA stroke com 000934, comma, as affirmed by the appellate forum, comma, to the extent that the respondent bank was directed to take all necessary steps to vacate the physical possession of the flat in question in favor of the complainant. Full stop. Next para. Accordingly, the bank accordingly the full stop. Next para. Can 1 of 2025 is disposed. Would you like to file affidavit in opposition? Or?
Second appeal.
I think that yes. Accordingly, can 1 of 2025 is disposed of in the light of the above observations.
Since no affidavits have been called.
Since no affidavits have been called for, comma, it is deemed that none of the allegations made in the application are admitted by the respondents.
I am the respondent number 1. The ideal is not represented.
None of the respondents are admitting. Yes, you are for respondent number 2.
My lord, one small prayer.
Yes, Mr.
My lord, by reason of the order which has just been passed by your lordships, will it be my lord's pleasure to say that all other orders or any other orders passed by the regulatory authority consequent upon this order, my lord, that 5 lakh costs which is hanging in my
This
head.
would affect, my lord, the other, my lord,
That will be
In that case, very well. In that
you can
case,
cite these in the other cases, but
no, true. So, my lord, but this order will not stand in the way of proceeding with the writ application which has been taken out by me. Because the
this order will stand in the way of nothing, suppose. We have not.
No, writ court is not entertaining it. This on propriety.
My lord, I'll submit that we don't have any difficulty in the writ court taking it up. We make it very clear.
Let that be recorded.
Writ court is taking up what?
There's
I have
another
moved a writ
petition challenging that
application.
order.
Subsequent to this order,
We make it amply clear that nothing in the above order shall preclude the parties from proceeding with any litigation pending before any court stroke forum.
very grateful.
Achha, we will direct you to file paper books and all also.
Yes.
We are not sure whether if it's like a second appeal, it should be heard by under single judge now. But this is not a second appeal. We are not
We'll
sure.
do it before
We'll
your
keep that
lordships.
vague.
Yes.
So,
Come back here.
We'll come back
no,
here. No.
we love you
This-
not to because this matter is
We would
complicated.
love to.
Yes.
No, but the appellant, achha, both of you are appearing, you are representing the respondent number 2. In view of the appearance of the respondents to the respective learned advocates, comma, service of notice of the appeal on the respondents is dispensed with. Post of the record should be brought, or do you have all the papers?
I think we have,
Informal paper books with, my lord, available records, my lord, if
That
there
should
is
be
anything,
sufficient.
that should be sufficient.
Yes. In view of the short ambit of the appeal, comma, the records of the fora below need not be called for at this juncture. Full stop. The appellant shall prepare informal paper books without comparing with the records. What would be a reasonable time for preparing?
3 weeks.
3 weeks would not be reasonable. We'll give you 4 weeks.
but then after the vacation.
Very well.
Hearing after the
Because the number of informal paper books without comparing with the records within May 20, 2025, full stop, advance copies of the same shall be circulated on all the respondents. Full stop, the liberty to the parties to mention the appeal for hearing as and when the same is otherwise ready.
Before whom lordship did not mention.
We'll deliberately keep it vague. And we'll try to ascertain from the rules that it is maintainable before a learned single.
The other matter, learned single judge actually heard.
Oh, very good.
SMAT 4 and 5, which Lordship was.
That's good. Sounds good.
But I'm not entering into that arena of controversy now.
Please don't.
You will deal with it as and when it arises.
Yes.
I'm very grateful to my lord.
একটা লাইন অ্যাড করে দিয়ে থ্যাংক ইউ ভেরি মাচ affidavit of service filed to be kept on record প্রথমে অ্যাড
Grateful, man.
থ্যাংক ইউ নেক্সট ইয়েস
Item number 38, Your Lordship, I am for the appeal.
সেকশন 5 ফাইল করেনি
There is a delay of 4 days, Your Lordship. I actually tried to find out the delay, but we found, Your Lordship, there is no delay. But stamp reporter, Your Lordship, has given, Your Lordship, noting that there are 4 days delay.
the appeal is against what injunction
Yes, Your Lordship, the injunction
just
application has
check
been
up, yes.
finally disposed of.
12 this is not from the city civil code
City Civil Code 30 days.
yes
So 12th of December
because of
2024.
December we have 19 days there
Yes.
gone 19 plus 10 so 29 days are gone when you apply
And we applied for the certified copy on 10th.
got it on 13th when did you file the appeal
We preferred the appeal on 16th January. So actually what happened, Your Lordship, 12th, 11th and 12th are Saturday and Sunday. So we could not obtain. I think 2 days delay, Your Lordship, on that basis.
11
Friday evening, Your Lordship, it was made ready. And we obtained the certified copy
no,
on
it was
13th.
made ready on 13th of January it was made ready on 13th as per the certified copy
Yes, Your Lordship.
13th of January is a Monday
It's a Monday. 11th, 12th, Saturday, Sunday.
11 12 does not matter
Yes, Your
because you had already exhausted 29 days
Lordship.
1 day was left
Yes.
now when you got it on 13th you had to file it on 14th
14. 16, 2 days.
you
delay.
filed 16 2 days delay
I'll file an application.
anybody appearing on the other side
No, there's no caveat, so we have not served, Your Lordship.
if anybody was appearing we could condone it on oral prayer also
We'll serve, Your Lordship. Kindly give me 1 week.
file a
time.
1-page application yes on the prayer of learned counsel for the appellant leave is granted to the appellant to file a condonation an application for condonation of delay file that application we will direct that application along with the memo to be served on the other side so that we can expedite the matter matter date dilam na acha the matter shall next be listed on you will take one week to do this
Hardly 1 week.
listed on May 6 2025 push up liberty to the appellants to mention the condonation application as and when filed for inclusion in the list along with the appeal
Should I serve, Your Lordship, then come back, Your Lordship?
no don't do that just file it mention it we'll keep it with the appeal
My lord, I appear on behalf of the defendant appellant, my lord.
right yeah for that
My lord, I have filed an application for stay. My lord, there is a typographical and
no this is
can one.
item 39 too. The appeal has to be admitted first
Lordship,
can one is stay application
stay application,
no first we have to admit the appeal what
Lordship.
is the substantial question of law
Lordship.
yes
My lord, the plaintiff has plaintiff case is that, my lord,
you're the plaintiff or the defendant
no defendant.
defendant
My lord, suit
it's a
for-
judgment of affirmance both the courts below
Yes, Lordship. Appellate
What
court
is the
affirmed
suit
the
for?
judgment of the suit for declaration of title and injunction.
all right so what is your question I mean
My lord, the only question is that, my lord, the suit property is a undivided property, and the plaintiff and defendant are the co-sharers, because the plaintiff and defendant both, my lord, purchased the land from the one owner and the same plot, from the same plot,
purchase undemarcated portion
undemarcated portion. But the
All right.
court held that there is a demarcated. Only in that sale deed, my lord, a chouhodi was mentioned and nothing more.
so that's one of the plausible findings why should you interfere for that we cannot substitute our views for that of the appellate court
My
if
lord,
boundaries were mentioned chouhodi was mentioned
chouhodi, only chouhodi, no
Then it's a-
boundary,
it's a-
no area.
chouhodi means boundary that's the translation of chouhodi
And my lord, there is no area also, only the
have you annexed any of the sale
yes,
deeds
yes, my lord, in the application.
please show us any of the
Yes, my lord.
schedules.
I'm grateful, your lordship. My lord, page 67 of my CAN application.
That's the beginning of that. Where is the schedule? Yes, page 70.
67, my lord, the page 70. Yes, lordship. I'm grateful, lordship. And last line, চৌহদ্দি উত্তর দক্ষিণ পূর্ব পশ্চিম. This much only.
And this is your deed? Or
No,
their-
my lord, this is in respect of my lord Gopinath, no, that is the plenty.
Plenty. And where
Yes,
is your
my-
deed?
Yes, my deed is, my lord, page 55 onwards, and Chouhoddi is there, my lord, page 63. Last 2 lines. উত্তর দক্ষিণ পূর্ব পশ্চিম.
Apart from the west,
Yes, my lord.
the rest, that is a
Only common is the
that is a
western
road.
side, road. That is a road.
That is a road. Apart from that, the rest of the adjacent properties as mentioned in the boundaries, those are different. If it was an undemarcated portion, the chouhoddis would be the same. It would be, suppose this is the entire property.
Lordship.
Eastern side this much, then many of the chouhoddis would be same,
Lordship.
apart from the middle.
Lordship. And
But here all the chouhoddis are different apart from the public road.
My
So
lord,
it's adjacent to the public road. 2 plots have been given to you.
Yes, lordship. And both
So it appears
plaintiff
to be demarcated.
and
Why not?
both plaintiff and defendant, both of them, my lord, the western side was given by the previous landowner.
So this is one of the plausible views that the demarcated portions were given. It appears to be demarcated.
And my lord, this plaintiff had filed the suit for declaration of title and injunction, and
Yes.
defendant also filed a partition suit. Both are pending, both are contesting by both the parties. Unfortunately,
Both are pending, then what is this against?
And my lord,
Both
unfortunately,
were pending.
both are pending. That is pending. But but the title suit, this suit has been decreed, and against that appeal has been decided.
It has been decreed, then nothing remains in your partition suit. It will be just dismissed.
My lord, in the partition suit, in respect of this title suit, my lord, my share was not decided at all, because
they claimed exclusive title over their portion of the property.
My lord, their portion is there and my portion is there. My share was not declared, since I have not filed any counterclaim.
Share, because demarcated portions, the courts found that demarcated portions were given to each of you. If that is the finding of
only the plaintiff. This is the problem. Only plaintiff.
Plaintiffs asked for his title, declaration of his title.
Lordship.
Exclusive title over a particular property.
Lordship, 166 decimal.
Yes. The court held on the basis of the schedule of his title deed that he has purchased exclusive portion on a particular demarcated property and declared his title on that.
Lordship.
Now your partition suit incidentally depends on the same, because you say it was not a demarcated portion.
Yes.
If it is not a demarcated portion, then you are co-sharer.
Lordship, I am the co-sharer.
But that has been held against you. It has been held clearly that the plaintiff has exclusive portion and this is a demarcated portion.
Yes.
Boundary is given, court finds this a demarcated portion.
And
that's a factual finding.
Yes, my lord.
But it's a question of law involved in
my
this.
lord,
It's not a question of legal effect from a factual finding
Lordship,
also.
total
No,
share
not
is, actual
perversity.
fact is that, my lord, total property is 2
No, we
acres
cannot
and,
go into questions of fact in a second.
2 acres and 19 decimal.
Only perversity, patent perversity, or at best legal effect of the terms of a document. These are not legal effects. This is a question of entirely a question of fact.
Lordship.
This interpretation, if the legal interpretation of a document pertains to a substantial question of law, then second appeal can be admitted.
Lordship.
This question of interpretation of the document does not pertain to any substantial question of law. It's a pure question of fact, not even a mixed question.
But
there is
but
nothing,
my lord,
no law involved
my,
in this.
my right has been affected because of the observation held by the trial court as well as the appellate court. As because, my lord, they have purchased only one acre 66 decimal. I have purchased 19 decimal, and since the
understand,
since court held that the land has been demarcated, actually there is no demarcation and boundary.
That is what you have argued. Yes.
And
sorry,
my lord,
sorry, no interference.
and my lord, the entire 185, they have purchased 166. They have 185 decimals land. They have already been started construction over this plot,
They
and
will-
they are enjoying this property.
No, sorry, no interference. The present second appeal has been preferred
And
against
my
the
lord,
judgment of
partition suit is pending.
The present second appeal has been preferred against a judgment of affirmance by the defendant in the suit. Full stop. The suit was filed by the plaintiff stroke respondent for declaration of the plaintiffs stroke respondents 1 and 2 for declaration of the title in respect of the suit property and for consequential reliefs. Full stop. Simultaneously, the appellant had also filed a partition suit. Full stop. The source of title of both the plaintiffs and the defendant is sources of title of both the plaintiffs and the defendant are two different sale deeds executed by the original owner, thereby transferring different portions of the original property owned by the owner, respectively to the plaintiffs and the defendant. Full stop. The defendant, in his partition suit, pleaded that undemarcated portions had been transferred by the original owner, respectively to the plaintiffs as well as the defendant, and as such, the entire conglomerate of the properties owned by the original owner remained joint, thus seeking partition in respect of the same. Full stop. On the other hand, the plaintiffs stroke respondent numbers 1 and 2 herein pleaded that demarcated portions were sold respectively to the plaintiff and the defendant, and as such, the plaintiffs have exclusive title in respect of the suit property, which is the subject matter of the present appeal. Full stop. Next para. Learned counsel for the appellant argues that a bare perusal of the schedules of the respective transfer deeds in title deeds of the parties would indicate that undemarcated portions were sold to them. Full stop. Although vaguely boundaries were mentioned, it is not clear from the deeds as to exactly what was the demarcation of the transferred property. Full stop. Next para. Upon a perusal of the transfer deeds annexed to the stay application filed in connection with the present appeal, we find that the schedules of the respective deeds encompass specific portions of properties, of particular measurements, with the mention of boundaries on all four sides in respect of the transferred property. Full stop. As such, we find that one of the plausible views on the yardstick of preponderance of probabilities was adopted by both the courts below by arriving at the conclusion that specific demarcated portion was sold to the plaintiff, thus declaring exclusive title and consequential relief of injunction in favor of the plaintiff. Full stop. Next para. We do not find any question of law involved in the present matter, let alone any substantial question of law, since the issue of interpretation of a particular deed on questions of fact, which do not give rise to any question of law, cannot tantamount to a substantial question of law for the purpose of admitting a second appeal. Which have been the light of the above observations, we do not find any substantial question of law involved. Which have accordingly, SAT 26 of 2025 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 1 of 2025 is also dismissed. Full stop. There will be no arrest to cost.
My lord, one thing, Lord. My lord, the dismissal of this appeal, my lord, will not affect the partition suit which is pending.
Definitely it will affect. that suit is barred by res judicata.
Because my lord, my right and title has not yet decided by this suit also.
Your partition will be refused. Why should we advise you?
Then my
Your
right
declaration
will
will be
then my
cancelled.
right will
You take proper advice from a proper advocate, please. Call on the next matter. Yes. সবকিছু একটা সীমা আছে এবার সুটটা ড্রাফট করে দিতে বলবো yes yes sir. No, you are for the respondent.
I am for the appellant, not led by Mr.
Ms. Dhamal is for the respondent number 7. They are supporting you, that's why. Mr. Chatterjee, you are with Mr. Chaudhary or against Mr. Chaudhary?
Well, I am, nobody takes me with, nobody takes me along with them, Milord. I'm always alone. Always alone.
Anyway, at least there is no doubt that Mr. Chaturvedi is for the appellant. Yes, let us start from there and then we'll.
You only respond.
Yes, plaintiff respond. Answer.
You too. Copy of the caveat. Why did you?
There was a problem on caveat.
It was there, not sir, order passed. I relied on the judgment of,
Your Lordship
Oh,
heard this
by the trial, by the. Acha. Yes. We were nervous for a second. No.
Lord, your Lordship not heard the matter on the other day.
Yes,
Lord,
Mr. Chaudhary, just please.
I only remind myself, Lord, of my submissions that I make, Lord, and in the process, Lord, recapitulate what I'm not submitted before your Lordships on the last occasion.
Yes.
Lord, a trust, Lord, Gayatri Chetna Foundation, Lord, enters into a memorandum of understanding, Lord, for the purpose of, Lord, propagating its object of, Lord, spreading education. It enters into, Lord, and executes a memorandum of understanding with George College, Lord, which, Lord, is a renowned, Lord, group of institution, Lord, catering in the educational field. Lord, among the other terms, Lord, the foundational terms were that representatives of this George College would be inducted into the trust, and Lord, the institution which is, Lord, formed would basically, Lord, be run, Lord, on the professional competence of George College representatives.
They would be funding you also.
Lord, the entire, Lord, management and affairs would be with them. Lord, we would be, Lord, funding them, except for, Lord, in the establishment of the building and other things, Lord, they, Lord, would render assistance.
Their infrastructure, your.
My Lord.
Your.
Now, Lord, this being the affairs, Lord, the institute, Lord, started running. Lord, admissions, Lord, took place. They collected admissions. We came to learn that admissions are being taken directly, Lord, under their ages, instead, Lord, of under the, Lord, academic institutes, Lord, ages. Lord, we raised objections. Then the employees of, Lord, this institute, they wrote to us that we have not yet received any appointment letters. At the same time, we were being sent checks for, Lord, incurring expenses to which, Lord, we had to sign, because the instructions to the bank were such that representatives from the trust and the representatives from the George College, Lord, who were now inducted in the trust, were, Lord, jointly, Lord, operating the bank accounts. Those were the instructions granted to the bank. So we asked for the details of the expenses which were incurred under the head of the academic institute, because we were given, Lord, checks which read, Lord, that the payee is George College. So we asked, Lord, for the details, and we also insisted that we shall directly make payment to the person who is the recipient instead of we giving it to George College. There are, Lord, letters which were exchanged, Lord, interse between the parties. Lord, finally, Lord, in March, in January 2025, Lord, we wrote a letter that now we put our foot down until unless you provide us with the details, because employees are sniffing on our neck that you provide us with the appointment letters. We even do not know whether these are on rolls of academic institute or on the rolls of George College. Lord, this being the situation, Lord, a suit is filed invoking, Lord, section 92.
Who files this? You file.
No.
They file this.
They file. Mr. Chatterjee's client, George.
Yeah, George.
Lord, institutes a suit, Lord, invoking section 92. Lord, seeks leave be granted under section 92. Lord, a caveat was filed by the managing trustee. Now, this managing trustee is the named managing trustee in the trust deed. This trust deed is relied upon by the plaintiff. It is one of the documents relied upon by the plaintiffs. No, ঠিক আছে।
সেটাই তো বলছিলাম। Some of the trustees of Chetna.
Right. Milord, I make it Milord clear, thanks to Mr. Chatterjee. Mr. Chatterjee is representing those trustees who represent the interest of George College.
I mean,
Milord, if
They are nominees. I mean,
they are nominees of George College. George College is not a party here.
no, no. Yes, yes. Yes, go. Very well.
So George is not a Milord party here. These trustees, Milord, who are representing the interest of George College.
And you are Chetna group.
Yes. Milord, I Milord represent Milord the trustees of the trust, Gayatri Chetna. And Mr. Basu is representing Gayatri Chetna, the trust. Milord, the managing trustee, Milord, the appellant number 1, Milord, she files a caveat. Milord, kindly sees Milord, a copy of the caveat, Milord, has been handed up to my lord today.
Yes. Gayatri Chetna Foundation is the caveator.
Yes, Milord, kindly sees Milord through the managing trustee. At a copy there. ঠিক আছে। Milord, kindly sees Milord through the managing trustee.
What is that? Because the name of the caveator is Gayatri Chetna.
Yes, Milord, then the address followed by through the managing trustee, Mrs. So and so.
That is not there in our book.
I'm sorry, Milord, the original copy is here.
Oh, no, no, sorry. In the first page, yes. In the cost title itself.
Yes, yes.
In the name of the caveator, only Gayatri Chetna Fund. Number 2, yes, very well. Fair enough, yes.
And
right.
Milord, the caveatees, Milord, kindly sees.
Manoj Joshi, Sriranjani Joshi are also there.
Yes.
Who are the respondent numbers 1 and 2?
Milord, they are the plaintiffs.
Yes.
They are the plaintiffs.
Yes.
Now, Milord, why, Milord, I say this?
So this was subsisting when the order was passed.
Yes. The learned court, Milord, takes notice of it, and the grounds why it rejects it, Milord, I shall place when I place the impugned order before my lord. Now, Milord, kindly sees, Milord, the plaint at page 203.
Yes.
Milord, kindly, Milord, sees, Milord, these are, Milord, the names of those plaintiffs, Milord, who are there, Milord, in the caveat.
Yes, yes.
Now, Milord, kindly, Milord, come to, Milord, the injunction application, which my lord would very kindly find at page 231.
Yes.
Now, Milord, kindly, Milord, permit me, Milord, to read, Milord, the last 4 lines of paragraph 1. The petitioners and the respondents are the present trustees of the aforesaid trust. Now, Milord, kindly, Milord, comes to page 248. What was the urgency pleaded? Milord, this is, Milord, I'm sorry.
248, you said?
248.
Yes. Yes.
Milord, this is, Milord, paragraph 33 in continuation. Milord, the last 5 lines of this paragraph starting on the right hand side with the words, thus within 18th March 2025. Thus, within 18th March 2025, the pro forma respondent has to deposit the semester charges and examination charges of all the students appearing for the ensuing semester examination, which is tentatively around 11 lakhs. But this is, Milord, the urgency which is pleaded. And why, Milord, they had, Milord, to file the plaint or the suit is because, Milord, kindly comes to page 150. I'm sorry, my lord, page 153. 153.
Yes.
Because these checks starting from page 153, 154, 155, and so on and so forth, these were sent to us and we refused to sign because they had not furnished the details of the payments which have been made and how they have been appropriated. Despite being asked for. I'm not pressing the letters. The letters are running into pages and are quite in number. If my lord takes me for my words, the letters are there that we sought for these details which were not provided. Now, my lord kindly comes to the impugned order. My lord would very kindly find that.
If you refer to the internal pages, Mr.
Yes,
Chaturvedi,
yes,
we'll just
yes.
follow the memo.
Yes. Kindly comes to the first page. It's this an order number 1 dated 7th March 2025.
Yes.
Kindly sees the paragraph starting with the words, this would be possibly 4th, 5th paragraph. It appears that one caveat being number 2074
Yes.
has been filed in connection with the instant case. However, though there is a caveat pending, but on careful perusal of the same, it appears that it is lodged by one Mrs. Anjana Meheria on behalf of Gayatri Chetna Foundation, but there is no resolution and authority of the said foundation. Furthermore, from the said caveat, it appears that the caveatees are related to George College and not with the Gayatri Chetna Foundation.
Anyway, bad order. Yes.
Lord, I pause here for a moment, Lord, before I proceed any further. I intend to address my Lord on this. As to my Lord, what does my Lord law says? If a caveat which is erroneous on any ground, Lord, kindly sees Lord, Rule 40, capital A of the Civil Rules and Orders.
এই সিভিল রুলস এন্ড অর্ডার্স একটা আনিয়ে রাখতে হবে। হ্যাঁ, সিভিল রুলস এন্ড অর্ডার্স বলুন, সিআরও বলবেন, তাহলে পাঠিয়ে দেবেন। লাইব্রেরি থেকে বলবেন সিআরও।
আচ্ছা, এখানে আরেকটা আছে।
হ্যাঁ, সিআরও।
I have another.
আরেকটা দিচ্ছি।
Lord, kindly sees Lord Rule 40, capital A, Lord sub Rule 10. When a caveat is not in proper form, my Lord, Justice Kumar has got it. Lord, kindly sees, Lord, or is otherwise defective. I say, Lord, that this was otherwise defective. Then the officer receiving the same shall forthwith place the matter before the presiding judge of the court concerned, and the presiding judge may allow the defect to be removed within such time as he may direct. Now, the filing is not in dispute. Now, kindly turn over the page. This is a suit under section 92 praying for decree of perpetual permanent mandatory injunction. This is a suit relating to a charitable public interest, and as such, leave under section 92 CPC is hereby granted. Blood, I say, blood, no words, blood, being spared to justify as to how the leave under section 92 is justified. But that very document at page 40, the trust deed, it says that the trust would be governed by the Indian Trust Act. The plaintiff relies on this trust document at page 40. It starts, the trust document, it starts at page 28.
Yes.
Now, the scope of section 92, my lord knows, my lord. Lord, in my humble understanding, Lord, this is Lord, not coming within the purview of Lord any of such disputes, Lord, which are enumerated in 92(1). This is a dispute with regard to the management and affairs of the academic institute, which is founded by the trustees of Gayatri Chetana Foundation. And the name of the institute is Gayatri Chetana Foundation Academic Institute. The trust itself is not the institute.
The institute is what is it? I mean, under the Societies Registration Act.
Lord, it is registered under the university. It has to be, Lord, has to have a separate entity.
What is it? An entity under which law? It's a society under the registration. Must be a society. Generally, these are societies.
No.
Not a society.
It is, Lord, registered as a campus of Macau.
What is Macau?
Lord, this is a university, the Maulana Azad.
No, that is an affiliation under the university. That is different.
It is, Lord, as a campus of that, Lord, this is not what.
Very good.
The subject to being corrected.
Anyway, we'll come to that later.
Look to 196. 196.
Page 196.
Then, if your lordship is not satisfied with that, Lord, kindly have a look at
Anyway, let him
62. And then before that, page 54. And of course, let
him complete. Let him say Chaturvedi, because we are. We'll come to it. Yes. Yes.
Now, Lord, kindly see, Lord, 92(1).
Yes.
And then, Lord, see, Lord, with regard to the subject matters over which, Lord, 92(1) would have an influence. Number, kindly see, Lord, removing a trustee, appointing a new trustee, vesting any property, directing a trustee who has been removed or a person, directing accounts and inquiries, declaring what proportion of trust property or the interest shall be allocated, authorizing whole or any part, settling a scheme, granting such other or further reliefs. I say that the scope of the dispute is not with regard to the management and affairs of the trust.
As per their plaint, what is the dispute?
As per their plaint, the entire
regarding the trust has been
nothing with not it. Admittedly, they are the trustees, so their status, that of a trustee, is not under any threat.
No, if it is regarding
the funds of the trust,
directing accounts and inquiries and all these things.
But we are not asking. We are only. Some of the trustees are saying, "How did you spend it? You send this to us so that we can sign the checks." But kindly cease. Milord, kindly sees, Milord.
Yes, Mr. Chaudhary.
But kindly, Milord, sees, Milord, page 225. Decree that I'm on the prayer of the plaintiff.
Yes, yes.
Decree that the plaintiffs and the defendants, being the trustees of Gayatri Chetna Foundation, the pro forma defendant herein, are bound to act in pursuance of the objectives of the trust deed dated so and so. Then, decree by way of perpetual injunction restraining defendants from doing any act contrary to the interest of Gayatri Chetna, further not to cause any obstruction in the furtherance of the objective of the pro forma defendant in pursuing developing the academic institution run under the name and style of Gayatri Chetna. Then permanent injunction restraining. Then injunction and then mandatory injunction. Now 92, my lord.
Why do you say it does not come in the 92? Because as framed,
yes.
Because 92(1) says in the case of any alleged breach of any express or constructive trust, breach of the trust created for public purposes, or where the direction of the court is deemed necessary for administration of such trust.
They don't say that there is a breach. They say not to act. They don't say that there is a breach. But the entire plaint, if read, but kindly see, my lord, the dispute, my lord, as I narrated before, my lord, I don't think Mr. Chatterjee would dispute, my lord, this, that the entire bone of contention is, why did we ask them the details of the checks that they sign, that they seek us to sign? Only this much. Only this much. Now, my lord, kindly, my lord, come back, my lord, to the order. Lord, I was on the internal second page of the order, and Lord, I submitted that no words have been spared to justify, Lord, as to why the leave under section 92 is, Lord, warranted to be granted.
Yes.
Lord, by filing the instant application, injunction petition, the plaintiffs have prayed for an interim order of injunction order directing the respondents to sign the required checks of Bank of Maharashtra, and also directing the respondents number 1 and 2 to execute all checks for disbursement along with petitioner number 1 for effective and smooth running of pro forma defendant along with other consequential reliefs. Now, Lord, kindly, Lord, comes to the next page. Rather, my lord, I should place, this is a small paragraph. I must place this. Having considered the submissions of the learned advocate for the plaintiff and the documents annexed with the application, it appears from copy of documents that there was huge transaction of so-and-so deposited by the student's concerned bank account, but only so-and-so has been debited from the said, and the present balance stands at so-and-so. It also prima facie appears from the documents that in spite of repeated reminders, the amount was not released to the respective academic institution. The tentative last date to form fill-up is 13th March 25 to 18th March 25. Prima facie, it also appears that there is a letter for non-payment of salary for the last 4 months. It also appears that if injunction is not granted, then future of many students would be ruined, as today is the 7th day of March and the last date of form fill-up is 18th March 25. It is also submitted that the amount of 3 months is immediately required to run the institute. So I am of the considered opinion that an ad interim order of injunction should be granted so that the future and academic careers of many students would not be hampered. Lord, before I place, Lord, the nature of the interim order, kindly sees on 7th March, Lord, the court is arriving at a finding that 92 leave should be granted. The caveat should be read down and not directed to be cured. There is still time. 7th, 18th is the last date. And then, the second paragraph, which is the ordering portion, the respondent defendants number 1 to 5 are directed to sign the required checks of Bank of Maharashtra for disbursement of examination fees and semester charges in favor of Macau and also respondent number 1 and 2 are directed to execute all checks for disbursement along with petitioner number 1 for effective and smooth running of the pro forma defendant, and further in the event of failure. The kindly sees, my lord, this. The petitioner number 1 and 2 are permitted to operate the bank account of pro forma respondents till so and so, to the exclusion of others. This is, my lord, I say, this is in mandatory form, my lord. When I had a caveat on record, now, Lord, kindly sees in the garb of this, Lord, what has been done. Lord, kindly sees, Lord, page 280. Lord, this is, Lord, the bank statement. Lord, all these withdrawals, my lord, self-withdrawals, my lord, would find, instead of, my lord, as an urgency was made out. Lord, these debit entries, my lord, would find are all, my lord, starting from 12th March 2025 till 26th March, and none of the entries, my lord, are in favor of the university. In fact, my lord would find self-entries.
119 was shown by you on the last time.
Blood,
page 282. Entry
blood,
number 119.
Yes. Blood, kindly sees, blood, page, the serial number 119. 119. There are many more, my lord. I kindly, my lord, turn over the page. Lord, kindly sees 168.
I have a chart if you lordship want.
Kindly sees
the self.
Yes, I have a chart. If your lordship wants, I have also, my lord, given everything of how it's been done.
Yes.
But 170. But this is how, my lord, the amount, my lord, has been appropriated. Although these are later developments, by intent to show to you, lordship, my lord, what urgency was pleaded, how court was persuaded, how an order is obtained, how the caveat is read down, how a leave under section 92 is granted, my lord, without ascribing any reasons. My lord, what is, my lord, the effect of, my lord, an order, my lord, which is passed, my lord, ignoring a caveat or reading down a caveat, my lord? A judgment has already been cited by Mr. Basu, my lord. He would, my lord, rely on it, I understand. My lord,
did you direct the appeal to be heard together? Where are the additional state?
That day, there was a question whether it would have been extended or not. That can be taken. If the original order is bad, you can take up.
No, there was a submission.
This is against an extent. This is against the original order.
No, there was a submission made. There was a submission made that there was no extension.
Still, I say there is no extension. I will show to you. How the extension, so-called extension has been granted, I will show to you.
So whichever it is, either it has been extended or it has not been extended.
Yes, Mr. Chaudhary. So
both ways.
my lord, 90 CW1, my lord, was cited to your lordships.
Yes. Right.
But copies, my lord, were handed up to my.
Where handed? Okay. Yes.
So, my lord, we are, my lord, really affected by the one, my lord, the mandatory form of the injunction, and my lord, the way, my lord, the leave has been granted, and the consequential steps, my lord, now taken, my lord, which have, my lord, rendered irreparable injury to us.
They must have. You have signed. You have executed. No.
No.
So they must have operated.
Yes,
in
yes, yes. Operated, and that the operations I have shown.
Yes.
280 onwards. Because then, my lord, there is no opponent. The goal is free for them to pour in as many as they can.
So we are admitting the appeal formally, and here Mr. Chatterjee on the stay application. In view of several relevant questions having been raised on fact and law, including as to whether the learned trial judge was justified in passing an ad interim order of injunction by overlooking the caveat on grounds dehorse the law, as well as whether the interim order of injunction, ad interim order of injunction granted tantamounted to grant of final relief, as well as whether the learned trial judge took into consideration whether the parameters of section 92 of the Code of Civil Procedure are applicable, the appeal is admitted to be heard on the above questions as well as the other grounds taken in the memorandum of appeal. Full stop. Next para, the stay application is now taken up for hearing. We have heard you, so we'll hear. Mr. Basu, you are supporting him. So, yes, you first.
Nothing more to add to the points of section 92. Past date, very fast date, I have cited the judgment. Order has to be recalled on that ground itself. How many? What is the amount? Total amount withdrawn is 29,63,000.
After this order.
Can you come to page 286? Indicate the total debited amount due of the bank. 9,68,662. Okay.
Yes.
And the ground of urgency is to remit the fees to Macau, the government university, constituted under the provisions of that. So it can be easily presumed no cash is deposited. Next, copy of the checks has been annexed in this proceeding by Mr. Joe. And Slot will not find a single check in favor of that. Not a single.
And the ground was semester charges and examination charges.
Urgency. It was persuaded on the ground of urgency that if the weight of the students are at stake, account has to be paid.
The university had to be paid. So,
Yes.
very good.
That's the ground. And now I have seen the result. Not a single check in favor of account. So, my lord, now we are coming, my lord. I will show to your lordship, my lord, see how the court is proceeding. But can you take this? On 7th, matter was taken up for hearing by my lords here. Up to 7th, my lord, interim order was there. Initial. On 7th, according to this order, they have filed an application for extension when I was entered appearance in the suit. No copy has been served upon me. Yes, on 7th this 12, it appears from this order that an application has been filed by.
On 7th, it was appearing before us.
Yes, my lord, hearing. On that date, my lord, an application, so-called application has been filed. Not only we have entered appearance by caveat, my lord, we entered appearance there. That order, this application for extension of interim order has not been served upon us. What happened, my lord, on 10th, an application has been filed under section 151.
It's mentioned in this order.
Yes. This 151 application has been served upon me.
151 also for extension.
No, kindly see the prayer. I am reading for the lordship. Please, therefore, it is prayed that the learned court make necessary please to modify the daily order. Kindly, pardon me, I am only one. Justice Kumar, kindly pardon me.
Yes, sir. Pardon.
Sorry, my lord, I have marked that. This is the prayer.
What is a daily order? They regularly get order. Daily strategy gets daily orders from the.
Yes, of rejection. Wherever Mr. Chatterjee is, they have a daily order of rejection. No problem. Order to pay. Order to pay.
আচ্ছা আর কোথায়
So, my lord, kindly see
এটা আলাদা এটা
how the court is functioning.
anyway থাক
আমার এগুলো যা পেছনে
পেছনে নিশ্চয়ই থাকবে আছে আছে এই হবে। হ্যাঁ, yes. Yes.
Seen that?
Modify daily order by recording the grant of exchange. What?
I don't know what is the meaning of that. Court must
What happened on 7th of April?
7th, no order passed. Now, wait. Now can you see the order? On 10th, on the application filed on 7th has been allowed to be extended, the order, but the application has not been served upon me. Can you see the tenor of the order? The order I have handed over to my lord just now. Application for extension has been served.
7th order is not with you.
There was no order. That's why this application.
No, there is an order.
There is an order.
Must have been an order. How can it be?
Today is fixed for SR of the Tribunal 227. Ajira for plaintiff is filed. Ajira for defendant is filed. For ends of justice, case is adjourned. And fixed on, then again, my lord, and this is.
George against it,
I'm just showing. No allegation is there. It was 21st April 2025.
The initial order was till 7th.
Yes, sir, order of first. Now that so-called
I forgot to pray for extension.
so-called
This happens here.
I'll tell you.
And on 10th, order was extended from starting from 7. So it can be said is reinforced. On an application which has not been served upon me.
Yes.
I was the which 151 has been served. The court should have allowed the application of 151. What is the prayer? Daily order.
Daily order has been modified and extension has been granted.
So
That daily order was that it's adjourned. That has been modified and extension.
case 151 was all served upon me. I concede. Can you allow the 151? What is the prayer? It will serve the purpose.
Yes, modify the daily order by recording the grant of extension of ad interim injunction.
On and from that date, that application, can you see the order now? Court has passed an order on
7th April, only adjournment is granted. And it is recorded that they have in a letter order that they have filed their account.
No.
That is now sought to be modified by recording that no, not only adjournment, extension of ad interim order granted earlier is given. So that is the modification sought in
So that application was on record. Can you see? Ground of presumption has been given. Can you see that?
But this is a subsequent, yes.
That on 7th there was an application. Inadvertently, court has not produced that. Can you see that order?
Where does it say that an application was?
Yes, madam, can you see this order?
Oh, is that on 7th of April an application for extension
And he presumption
has been filed? You must have treated that.
The last paragraph of the first page. Upon hearing the both the sides on the technical of the order sheet dated 7th April, the official status report of cause list, it is suggests that it appears that total 197 court fees in the application have been filed on 7th April, out of which one application with 2 court fees of ₹10 and one have been filed in connection with the instant suit.
No, they have stated in that application, that 151 application, that on 7th of
They have filed.
April,
Yes.
extension application had been filed.
The application which has been allowed now by this order.
151 was given to you.
151 has not been allowed.
In the 151, it was written that it is stated in 151 that on that date we had filed extension and please extend that order.
When a case where my lord caveat was law ignored.
That application is not being allowed. 150, that 7th-4 application is not being allowed. They say on that date I filed an extension application. That was not decided. So therefore, please modify that order and grant an extension on the basis of this 151. And that has been granted.
The last line. Hence it can be presumed.
Hence, the application under section 151 CPC 5 by the
They say they cite actus curiae neminem grave because that application that they have stated that in paragraph 7. Because that application was filed, you did not take it up. Please modify the order of that date and extend that interim order granted earlier. That extension period is made here also.
But
Extended.
that date's application was allowed.
Yes.
Which I say?
Retrospectively, it was.
Which I say? Not been served.
But you must have opposed this also.
Yes,
This 151.
yes. I'm saying that the application has not been served.
That is the only opposition.
But thing is there, on merits also something.
But this is subsequent. Let us
So do not fit how the court is proceeding.
with prejudice value.
Claim
Prejudice value. Yes. We are prejudiced. Yes.
Now, first, the prejudice value.
Yes. A caveat was there, Mr. Chatterjee.
No, that I'll explain.
That prejudices us most.
I understand. I'll explain that.
Yes.
The first one, my lord, first prejudice of Mr. Basu, my lord, I don't know how he says this, takes up the order, my lord, of order number 8, which is on 16th of April. Which is, he says, my lord, where the 151 application was being heard. It is there. My lord, on
What order?
order number 3, my lord, your
Let me
lordship
find
doesn't
it.
have that order. I'll read it out for your lordship. This is on 13th of March 2025. The case record is put up today on the strength of the petition of the applicant, defendant number 1, namely managing trustee of the Gayatri Chaitra Foundation, along with the petition for vacating the order of injunction. So they appeared, my lord, on 13th of March, defendant number 1, along with the prayer, my lord, for vacating the order of injunction. Let the record be fixed on 19th of March for hearing of the petition for vacating the order of injunction, written objection, if any, in the meantime. This is 13th of March. My lord, this is the order, my lord, your lordship kindly looks at. Then,
Yes. A vacating application was also filed.
yes, sir. It's there on record.
What happened to that?
Nothing has
that
happened.
was that should have been taken up before extending
Should
it.
have been. Should have been. They did not press for it. I'll show your lordship that. Today, 19th of March 2025, Lord comes back. Lord comes back on the first page. Today is fixed for hearing of the petition for vacating the order of injunction. Written objection, if any, in the meantime. Written objection is filed by the plaintiff against the petition under 151 for vacating the order of injunction. An application for revocation of leave is filed by the defendant number 1. So, with respect to that, Lord, they have also filed an application for revocation of that leave, which is still pending also. Then I come to the prejudice value, my lord, takes up order number 8, which was cited by my learned senior friend, Mr. Basu, and looks to the third paragraph.
Order
He
number
says-
6 was cited.
Order number 8.
8 is not before us.
That's
the last one.
Yes, my lord. He was my learned senior friend
Yes,
said
yes.
that
You
he
are
was
right.
not given, my lord, the
Right.
copy. Looks to third paragraph.
Yes.
I am not even going to read it for your lordship.
Read it for us.
Defendant number 2
Why?
appears by
What
filing
is so
Wakalatnama
bad in that?
along with written objection.
Yes.
So no question of not being served. If he was not being served,
No, this is 151. Written objection against 151.
yes, so that's his.
No, 151 he's saying copy was served.
No, he's not saying so.
Yes, yes. He has been saying 151 was served, but previous application was.
Then what
Extension application dated 7th of April was not served.
the
151 served and they filed written objection.
on 7th of April, no, it was not extended.
Not extended, although you had filed an application.
Had filed an application.
Subsequently, you filed this 151, you said actus curiae and
Yes.
please
And
extend that, allow that
that's
application.
7.
Yes,
That,
yes.
my lord, says
That
no
is clear
question
before
of
us,
his
yes.
prejudice at all. When it was extended, my lord, that application was
So let
served
us come
on.
back to the impugned order first.
Now,
These
let
are
us-
subsequent
I'll-
events.
Before that, before your lordship goes
Because
to
the subsequent events, we are bothered only with your not depositing anything to make out that we are bothered. That you'll have to
that
do.
is a completely
But nothing
false
else
statement.
matters. I mean, whatever way the
That's
court
an
proceeded.
absolutely false statement. I'll tell your lordship. My lord, first, your lordship needs to, my lord, on facts. With a lot of respect to my learned senior friend, there is a problem on facts.
How?
The first thing is, my lord, the trust, which is Gayatri, was formed, my lord, by a trust earlier. That's the original trust, where, my lord, Mr. Chaturvedi's clients were trustees. No, Mr. Basu is the trust. He's the trust. The factual email, it's a little difficult. Now what happens is, the object of the trust is to set up, my lord, an educational institution. Because they didn't have the wherewithals, they went, my lord, to another company and said that please come in and help us. That institute which he says, my lord, is George, which is a unit of George Telegraph. They bring in 5 persons, my lord, from the George Telegraph. and they induct them as trustees in Gayatri. Now, George is nowhere in the picture. I am 5 persons from
Entered
George.
into a written agreement with George.
Yes, not, I'll show you, Lordship, it's all there.
George.
With George. And these 5 persons, my lord, are inducted as trustees into Gayatri. And now Gayatri now, my lord, after the modification, has 10 trustees. 5 Mr. Chaturvedi, 5 me. The entire trust is run, my lord, is being run basically, my lord, for an educational institution. This educational institution, my lord, is registered, my lord, with MACOUT, which is Maulana
This
Abdul.
was formed after you came in.
After I came in. After I came. That's why I said, you know, the facts are, which was stated by my learned senior friend, was not correct.
No. Gayatri was existing.
Gayatri, the educational institution was formed after.
No, Gayatri was there, my lord. I came in, I was inducted into that.
By Gayatri, you mean the trust?
Trust.
Not the educational institution.
No, educational institution is a part of the trust.
And they are the trustees.
The educational institution was being run by Chetna.
Yes, yes.
Gayatri was.
Yes. And I came in and
As
I am
5
now a
trustees.
part of that educational institution, which of the trust which runs the educational institution. Let's put it that way. Now what happens is this educational institution, my lord, is affiliated to an university. This university is MACOUT.
Right.
Now what happens is, and during the month of March, when the 3rd semester, the 2nd semester exams start, the money has to be deposited, my lord, from the students directly to the university. What happens is when we had taken, my lord, admission of these, my lord, we means both of us. Entire money was taken from the students, including the money to be put into MACOUT, so that they, my lord, can sit for the examination.
You have to pay on their behalf.
We have to pay on their behalf, but the university doesn't take money, my lord, from the college. It takes it directly, it takes it directly, my lord, from the, my lord, from the students. Why?
Then why did you take it?
I'll tell you, Lordship. Why? Because, my lord, we don't have net banking. Because we don't have net banking, we could not pay directly, my lord, to the university, because everything has to be paid online.
You don't have net banking?
No, I don't have net banking. It is an admitted fact. They will understand that. That's why checks are being sent. We don't have net banking. Because it's
the trust does not have.
My lord, the trust doesn't have a net bank. It's an admitted fact. They are a member of the trust. They can't deny.
You have an account in which bank?
This is, my lord, Bank of Maharashtra. Now, my lord, what happens is, since we cannot, my lord, put in the money, my lord, on behalf of the students, we ask them to sign the checks so that the money goes back to the students. And the students can pay directly to,
in the first place, why did you take the money from the students? If
because
you can't,
at that point
if
of time,
those had to be paid directly.
At that point of time, we have to. My lord, if we had net banking, there was no problem. It's an anomaly of the trust. I bow down.
No, the students have to directly pay to the university.
Because net banking is not there with us.
If there was net banking, how would it help you?
If there was net banking, we would have sent it online to my account.
Then you would have been sending those, not the students.
I would be sent, definitely. But the money has to go, my lord, through online process.
Say that the students, not that the
online
students directly mandatorily have to pay directly. You said that only.
Because I don't have net banking. So what I did was, the money which I took from...
You knew you did not have net banking when you took the amount.
I bow down. Because this is a problem which has happened. It's not...
All right, they were also a party to it.
Yes, party to.
So we cannot dwell much on that. Both of you.
We wrote a letter to them. Send them checks.
You wanted to send back to the students directly?
Yes, my lord. And we have done that. Kindly have a look at this now and satisfy my lord's self.
Give a copy to them at least.
Yes, definitely.
No, this should be reflected in your accounts which they have annexed also.
My lord, it's there.
This is a
chart brought out from there, my lord, statements.
These are the entry numbers, serial numbers. These are the serial numbers.
Serial numbers. The refund made to the students, below the serial number on the statement of bank account that they have given, 4 to 31, 116 to 117, 118 is 11,26,287. My lord, this is what we have stated in the affidavit annexing, my lord, the accounts.
Now, what is the mode of it?
I think Mr. Basu hasn't checked up. the statement.
No, no,
have
the
a look at
statement from the
168.
statements. Page 280. Please come to page 280. Suppose 4. Orchona Barai. 5. Auritra Nando. Check by check.
Then
The check numbers are there also. Check reference number is there. In the entries.
through whom money?
Checks given directly to the students, they are saying.
Aye, that's the order placed by the trial judge.
The purpose for which the injunction was obtained, they say that they have complied with that.
Arey
Come to page
nah.
280, it will explain. Have you got a copy of this which they handed over right now? See, 4 to 31 they have said. What are these? NA and GST cannot be that. Mr. Chatterjee, NA and GST are there. 4
Yes.
to 31 it cannot be. Oh, that is NA and GST on that Auritrunanda and all. The next answer. Yes, yes, all these are individuals' names, right, right.
All these are individual students' names. From where did I get it, money?
Mr. Chatterjee, Mr. Basu, you are not understanding. Check numbers are given in the bank account you have produced. Please take your seat. Let Ms. Dhamali explain to you first about banking, then come up.
Sir, he only
He's equally literate as I am, but I am now understanding after seeing this. And the most competent person regarding banking is making me understand.
Mr. Mukherjee, please take over. I have no clue about
Not only on the vehicular route, but apart from vehicles also, I mean, otherwise regarding banks in general.
I've said I'll sue him. He has
I can only add that I managed to have a bank account.
Yes.
so this is
That
11.
would, our bank account could put many people to shame. I mean, for the wrong reasons.
Mine to definitely. 100%.
Actually, Mr. Chaturvedi, on a lighter note, I mean, now we can be lighter on that. I could fully identify at that point of time. Fully identify with you. I mean, it was just a matter of luck that at that point of that was not relevant. Fully identify.
Yeah, we understand that.
Yes, all of us understand. All of you understand. And there's no difference. Only a stroke of luck.
No, that is Milord, your lordship was born with it. He was born to earn money. Can't help it. Your lordships were born to Milord,
make people earn money.
Serve the sovereign.
So these are the charts
the
about
charts,
very well.
the number which they were trying to say that
vendor payments and all these are
everything is given, and this is in compliance of Milord, the order of injunction which was granted.
Understood. How do you get over the caveat aspect?
Okay.
That is very risky. Have a look. Have a look. No, we are not closing anything.
Kindly have a look.
Yes.
Why I gave your lordship the first thing about the caveat. If your lordship sees the impugned order once.
No resolution and authority at the caveat stage. That was. No, and even if that we so, as Mr. Chaturvedi rightly pointed out, Rule 40A is there. CRO.
No.
I mean,
what is 40?
Caveat is there.
Caveat is there, my lord, but the caveat was lodged with respect to George. There is a difference with, that's why I'm...
No, not only that.
Yes, it was with respect to George. Kindly have a look at it. Have a look at the caveat. If I'm not mistaken, I have, my lord, it was completely between the court and the plaintiff. I did not have the, my lord, the occasion to look at it. The department and the court. I had got no role to play here. The court has recorded that it is...
But Gayatri Chetna Foundation is the caveat.
Yes, my lord. The name is there as George. Kindly have a look at it. I am not here.
No. The name of the applicants, proposed applicants is, one is George College.
Yes, then.
Two, Manoj Joshi.
Trustee of George College.
No, not as that. No, just see column 4. You have got a copy of the caveat. Please come to page 3, item 4. Individual capacities also.
No, Miller, kindly look. I'm sorry, Miller, never.
Yes, no, please.
Page 1. Page 1. Manoj Joshi, trustee of George College. 3. Shriram
Their
Joshi,
names
George
were there,
Joshi.
Mr.
Names
This is
were there,
hypertechnical.
but
That is not the reason
why
given by the trial.
He has explained it in his order.
What is the explanation?
He said that this is on the basis of George.
Caveat is related to George College, not with Gayatri.
I am not George.
No, the court is saying it appears that the caveatees,
yes,
you,
yes,
are related to George College and not with Gayatri Chetna Foundation.
Exactly. So my capacity here is not as George. And court is absolutely correct there.
But your individual names were
The
given.
names might have been there, but my name, my lord, I file a caveat, Aniruddha Chatterjee, vis-a-vis, my lord, X. But Aniruddha Chatterjee, vis-a-vis, my lord,
Cost title, we cannot look at the cost title only. You have to see the substance.
yes, my lord.
The particulars of the caveat do
Yes,
not name you as instrumentalities of or
My lord, all
functionaries of-
George College, everything George College.
No.
Trustee of George College.
particulars. We have to look at the particulars of the caveat,
Lord,
not the cost title.
My lord,
Particulars can kindly come to the particulars.
My lord.
Item 4 is clear.
yes, my lord. And there are
Name of the applicants in respect of the application against whom caveat is lodged.
number 6 at page 4. That's the particulars given. Everywhere, George, he's given the particulars. He said that this is George. The judge is not wrong.
Then how can you overcome order 40 rule 40A that
them show the department, not for me.
no, the
That
department
is a
was
def-
to
if there is a defect with respect to the caveat.
court finds time to say, court looks into the caveat,
Yes,
court
my lord.
says that there is a defect in the caveat.
No, the court says that this is not with respect to
Then court
Chetna.
looks at the caveat.
Yeah, my lord.
Court looks at the
Yes,
caveat.
my lord.
Under rule 40A,
Kindly have a look at that.
yes, please just
Have a
take a look at that.
48,
40 is very clear. 10.
As far as I remember, my lord,
When
we
a
don't have
caveat is
copy.
not in proper form or is
Exactly,
otherwise
not in
defective,
proper form.
or is otherwise defective, the officer
Defective. It's not
receiving the same.
defective. It's not defective. What is the defect?
Oh, you see it is in form and in
Ah,
other very well.
ah.
There was no occasion for it to be placed.
No occasion to be placed. So if they take a point, now, my lord, what they've done is they've gone back to the court and filed 2 applications for vacating as well as the vacating the leave to under 92, revocation of 92. So this is not that, my lord, that there were some ministerial errors, my lord, in the KV. Aste, aste. So 40A, my lord, doesn't affect me in my respectful submission.
Resolution and authority, probably that could not be looked into at that
The
stage.
learned judge, my lord, it's really not my, my lord, it's not my doing. I had
Correct.
not no problems at all in serving in any way.
No,
But
section.
what played with the judge was there was an emotional aspect here.
What
Because
emotion?
there were so many students
Students,
involved.
yes.
If they did not sit for the exam, then my lord, it would fall upon them as well. I think it my lord, played with the learned judge.
No, that is reflected in the order
It
also.
reflected in the order itself.
And section 92 CPC not applicable.
And
What
see,
about
my lord, if your lordship sees the order, it was a conditional order. If your lordship sees the order is, it safeguards both parties.
accounts?
And I've given
And
your
the
lordship.
subsequent order says that you have filed a
I have filed account. What I have given to your lordship is a part of my affidavit in the court below. So there is no, my lord, but in my respectful submission, there is.
So this is not a 92 scenario. Mr. Chaturvedi has also argued that.
I'll show your lordship that.
This is
92
not a
scenario.
dispute regarding the trust.
I'll show your lordship. Comes back, my lord, to the first, my lord, page 25. Comes back, my lord, to page 25 on that, with respect to what my learned senior friend said, that it does not fall within the purview. Turns to 28. My lord, may I once, I see a smile. I don't know what it is about. This is something, my lord, which has come up today.
So tell us what is this, please.
This is an application filed by them, both the defendants, asking for time to, my lord, file written objection in terms of Order 41, Rule 1, and, my lord, to set a and to, my lord, hear out the application which they have filed in the court below for revocation of leave.
No, Order 41 Rule 1?
That's a mistake, I'm sure.
This is 39.
It should have been 39.4.
No, 39.1 and 2.
No, it has 4.
No, 39.4, they would be filing 39.
Yes.
Written objection to main injunction.
They wanted to file a written objection to the injunction.
Injunction application and the leave to, my lord, revocation of leave. And this has been granted today to them. So they want to proceed in the trial court. I
No,
don't
that
know
there
why.
for abundant question, they may be challenging.
I
and
don't know. They want to do it, my lord. Again,
Why should
your
they take
lordship
a
was on prejudice, so I was also trying to. Now, kindly turns to 28.
Yes.
This is the Gayatri Cheta Foundation, the original trust, which was formed in 2018. Looks to the object of the trust, below. Kindly turns to page 33.
Handwritten 33.
Yes.
Yes.
The objects of the trust herein stated above shall come into effect of force after obtaining necessary consent of competent government authorities.
This is not relevant.
No, thereafter. I'm sorry. The object of the trust is something which is jeta bolto ke dekhalam ekkhuni. I'm sorry. I'm really sorry. 31.
31.
Paragraph 5.
Yes.
And then paragraph 6. C is B.
So Indian Trust Act, you
My lord.
yourself say that Trust Act.
It is.
So you file a section 92 application.
Yes. Yes. Public, huh? Public. This is for public. C is 92 6B. Promote, establish, create, open, set up, run. It doesn't apply to a charitable institution, religious charitable institution. Run, maintain, and administer schools, coaching and training centers, colleges, institutions, universities, and other education institutions by whatever name called for imparting education, training, and coaching. This is the main objective.
What
Then,
are the plain allegations? What are
yes,
they doing?
yes.
But
Now
we have to see
kindly-
whether that comes within 92.
Absolutely. Kindly turns to Miller. The plane starts from 194.
Yes.
Kindly turns to, no, I'm sorry, this is the leave application.
No,
No.
plane starts from
I'll
page
tell you.
200.
203.
203.
Kindly see paragraph 23. I'm sorry, see first 11, where Macout and everything is being formed. 12, again, your lordship will find from George that there are 76 students, your lordship will find at paragraph 13 at page 213.
Yes.
I just quickly, otherwise, it will take a long time for your lordship. See paragraph 15. The plaintiffs say that in terms of clause 22 of the said trust deed, coupled with modified trust deed dated such and such, it would be apparent that all expenses are to be channelized through the banks and the signatories of the banks are determined in terms of clause 22 of the said trust deed, and we've given that for your lordship's consideration. And they are one of the signatories. Then turns over, my lord, to paragraph 16, sees the second paragraph. My lord, I'll just read it for your lordship, Lord. Therefore, in practice, the bank account of the pro forma defendant is being operated by joint signatures of either the defendant number 1 or defendant number 5, and any of the plaintiffs who are usually Anjana Meheria and Manoj Joshi. That's my learned senior friend's client and me. In fact, the plaintiff number 1 and defendant number 1 have been all along jointly executing necessary checks for disbursement of the expenses to be incurred by the pro forma defendant in running the academic institute. Even all payments that are received by the academic institute are deposited with Bank of Maharashtra branch. As such, neither the defendants nor the plaintiffs can solely handle the funds of the pro forma defendant for making necessary payments towards salaries of staff, maintenance charges, impress charges, vendor payments, mandatory payments to Macout, etc. in relation to the academic institute. 17. Pursuant to the memorandum of understanding dated.
So you say that since the academic institute is being hampered due to the affair, that is one of the objectives
One
of
of
the
the
trust,
objectives
and
of the
therefore the
trust.
trust is being frustrated.
That is very, very evident from paragraph 23.
18 also.
18 also and 23 again. Page 219. Specifically, we've put it out all on record. All on record. So what they were trying to do is, my lord, if the institute doesn't work, if the students can't function, then the entire object of the trust is going, my lord, to the doldrums. This is simple. There is nothing, my lord, any sort of complications in it at all. Looks to page 219. If your lordship wants, I will read out for your lordship. Then kindly turns over, my lord, all these email communications, we've requested them to make payments.
Mr. Chaturvedi, if you stay the order, then there will be no functioning because you are at loggerheads. The functioning of the trust and the academic institution would stop altogether. So, because on these papers we are virtually hearing the appeal. So we'll indicate, since you have already admitted the appeal, will indicate that we'll take up the appeal and the application. We'll continue hearing the appeal and application tomorrow. I mean,
My lord.
appeal and application both will be deciding together. We'll making it a part of our, we'll make it up because we have 2 minutes left today.
My lord.
So we'll continue tomorrow. So whatever they have done, they have, it's on record and there's a direction for accounts, the direction of accounts also. No, I don't know.
Make
How
it
can-
It is experience.
No, not necessarily because it has to be supported by bank statements.
Huh.
And they have produced, handed over a document where they have given certain accounts. Yes, you do that also. You definitely will do.
Then keeps it day after tomorrow. Tomorrow might be difficult. Keeps it day after tomorrow.
Checking he will do when even
I
after
don't
the
have a
disposal of our appeal, Mr. Basu can go on checking and put it before the trial court. No difficulty in checking. So let us continue. We will
Very-
use
I don't
continuity.
have a problem. I don't
We'll keep it under the same heading, but it will be.
Formal appeal has been filed.
Your appeal, you give the number. Since in effect, comma, the adjudication of the stay application involves the hearing of the issues raised in the appeal as well, and we have substantially heard the said issues. Substantially heard learned counsel for the parties on the said issues today, comma. The matter be due to paucity of time, the hearing cannot be concluded today, comma. Let the matter be listed tomorrow under the same heading. First up, let it be understood that the appeal along with the application are being taken up for disposal.
Could it be, my lord, under 4 orders heading, my lord, so that some precedents?
There are applications, too many applications, urgent applications before this. So this is under the order 41 heading, not under
Yes,
hearing. So we reach order 41. Yes, yes. What is that? Your card?
If it was a card, I would have snatched
What
it.
are you handing over?
For him, my lord, it's very difficult
দেখুন
for a
আনিল।
card.
কালকে
I'm
इसमें
sure your lordship knows it, but never spent the money on anybody.
Oh, Mrs.
Mr. Basu.
No, when he was conferred with the senior account, I ate there. I'm a beneficiary of that.
That's the
That I
only time,
remember.
and I missed it, unfortunately.
Lordship,
Yes, yes.
Lordship, in the morning, Lordship,
Yes,
I had
Lordship,
sought
sir.
for leave.
Leave.
Notary, Your Lordship, I had sought for leave that the petitioner resides outside the jurisdiction of West Bengal, and Your
Not
Lordship.
taking it.
No, Your Lordship.
To leave note just let me see the document application. Copy. Just having very good. Memo, why should it be notarized? Memo,
Lordship, the stay application was also notarized, Your Lordship. I had indicated that
memo, how can the memo be notarized? Memo is filed by the appellant, the advocate. Vokalatam has to be there. Vokalatam is there. Why should you notarize the memo? Where is the application? Oh, this is the application. But this is the memorandum you have given a caption application.
Lordship, there's a stay application also. It's there in the filing section. They are not allowing us because it has like notarized.
Because the memo's not been filed, my lord, they cannot allow the stay application to be filed. You
Have to file the memo first.
Indeed, Your Lordship, if Your Lordship
File the
kindly-
memo. We have granted leave to file memo.
Lordship, they are not allowing.
It a guy লিখে দিন to leave to file. You have not annexed any copy of the order also.
Your Lordship, we have the copy of the order.
When we grant leave to file an application, file a memorandum of appeal without the certified copy, you have to file a copy of the order. Where is that? It does not contain a copy of the order.
Lordship, I'll
You
attach
properly
it,
check with the proper clerk, please. Somebody who knows the law.
Lordship kindly grants the leave to file.
No, we cannot grant leaves like this. You are misusing the leave. We have granted leave in the morning and we are seeing now that the memo, we didn't even look at the memo. The memo does not contain any photocopy of the order also.
Lordship,
Or a
we
server
have the-
copy.
Lordship, we have the photocopy, Your Lordship. It might
If you have
be-
the photocopy, keep it bound and hang it on your wall. It's not with the memorandum. You are misusing the leave. How
Lordship,
can the department is absolutely right in not taking your application? We withdraw our leave. You
Lordship, I'm
tomorrow
sincere-
come back with a proper memo and after checking the memo only we will grant the leave. This contains nothing. A memorandum notarized. Who is the clerk who is doing this? His license should be cancelled.
Lordship, I sincerely apologize, Your
No,
Lordship.
no, you need not apologize, but this is not the way to do things.
Lordship, there's some.
Take the help of a proper clerk who does civil matters.
May I take back one extra copy of the caveat that I have filed? There are 3 copies, my lord.
Oh,
One which has a slip over it. But kindly do not take the trouble, my lord. I shall, my lord, take
না,
up.
আপনি পিছু স্যারকে দেখিয়ে দিন পিছু পাবো ওনাকে ও সেম হেডিং না তাহলে tomorrow under the heading application it will appear under the heading application we have already admitted it will go a little up
কেন করতে দেবে না লিভ দেবে দরকার নেই তো এটা